Okay, we're live, Mr. Chairman.
Committee, let's call this meeting to order and roll call, please.
Good morning, Mr. Chairman. This is roll call for the Joint Ag Committee for November 14th. Senator French.
Here.
Senator Kolb.
Present.
Senator Cost.
Here.
Senator Wasserberger. Representative Blackburn.
Here.
Representative Clausen.
Here.
Representative Portner.
Here.
Representative Heiner.
Here.
Representative Larson.
Here.
Representative Western.
Here.
Representative Worf.
Here.
Representative Winter.
John.
Co-Chairman Boner.
Here.
Chairman Eklund.
Here,
Mr. Chairman, you have a quorum.
we have a very complete committee this morning. This is a good thing. Thank you, everybody, for coming. I'd like to welcome everybody to our joint committee meeting. We have quite a bit of material to cover this morning. And I think that we'll go ahead and start with the first agenda item. So I think the Office of State Lands and Investments could come forward.
Morning, Mr. Chairman.
Welcome.
I'm Jennifer Scoggin, the Director for the Office of State Lands and Investments, and with me is Jason Crowder, the Deputy Director. It's my understanding that the first item on the agenda are the state lands leasing decisions, following up and continuing from the June and September meetings. We don't really have much to add at this point. We have provided the committee with information concerning all of our leasing processes. We've provided the committee with flow charts to help sort of explain those leasing processes. We've provided, with respect to the Wagon Hound Lehman matter, we've provided our complete file on that. We've provided the Office of Administrative Hearings recommended decision. We've provided the decision issued by the board. We've also provided OAH's recommendations on 3 other matters that were going on about the same time. And we've testified, I think, in great detail on all of it. But we would stand for any questions that the board might have at this point, but I'm not sure we have anything else.
Thank you. Also online, we have our state treasurer, Kurt Meyer, and we would like to have him, as much as he can, represent the Board of Land Commissioners. Kurt and I have a little history together. We're from neighboring communities, and we served on as co-chairman of the Joint Transportation, Highway, and Military Affairs Committee for a few years, and it worked really well. We got some good things done. Anyway, welcome, Mr. Treasurer.
Thank you, Mr. Chairman. I can't represent the board because I'm only one member, but as the director knows, once in a while I have opinions, and you guys know that too. So as you go through here, I'll take some notes and opine a little later on about perhaps some legislative fixes that might add clarity to some different situations.
Okay, committee. Do you have anything for treasurer? Yes.
Well,
Mr.
thank you,
Chairman.
Mr. Chairman. And thank you, Mr. Treasurer, for being here. I understand you're traveling. I appreciate you going out of the way to be present at this committee meeting here. I think we benefit just from understanding the process from your perspective. I think we got a very good understanding of the process Office of State Lands and Investments goes through. But if you could just kind of share your overall perspective of how this works as a member of the board, to include the role the Attorney General plays in advising you and how that may be different from the advice State Lands and Investments may provide. Just a little overview of the process would be really helpful, I think, for the committee.
Well, I think it kind of depends on the matter before the board. I found that and as you guys have found out of some of your legislative actions, that sometimes the advice of the Attorney General, and this just isn't the advice of this Attorney General or the actions of this director, but it's been of previous directors and previous Attorney Generals, as far as when we looked at the vacant land issue. And I had thought, and I think you guys fixed the problem there as far as the ambiguity that might have existed in the law. I think it was fairly clear to me that if you had adjoining land and it's a vacant land, that you did have a preference. And that preference was essentially omitted in the rules, and as if it never occurred, and we didn't take the time to define it until a little later on, where you guys had made that decision to actually make sure that it was expressed clearly. So those were things that kind of I think get in the way of the intention of the legislative process and the work that was done, and sometimes the work that you guys may do. And this isn't just in the areas of state lands, but the Attorney General always defers to the agency. And the reason they always defer to the agency rather than the board or the public, or in that manner the legislators, is because they are thought at the outset to have the expertise and the knowledge to understand the issue better than anybody else. It's that deference sometimes where I think that and that's just the process that has always gone on, whether it's in water, whether it's in land, whether it's in any other area. That's just the way the rules work. It's the way the legal system works. To go to court, it's the same way. So it is kind of frustrating, but that's what necessarily. That's the facts as I see them, and I think as they're presented to everybody in our I guess relationship with government. That being said, I think the best thing to do is to try to make sure that when we do statutes, realize that try to take the ambiguity out of them as near as possible, and that. I think that'll go a long way into making sure that there isn't any misinterpretation of what your guys' intents are. And then the other thing that I know that I don't believe that we did enough of when I was in the legislature, and I'm not sure where it is now, is that every committee gets the opportunity to go back and actually study the rules and regulations that were promulgated in regards to your legislative actions. And I would hope that maybe sometime in the future that might be the one of the topics on your interim committees before you get back in the session, is to make sure that the rules were written, actually have some committee discussion about it. So you know that they were written the way that you intended it to, when it was fresh in your mind when you from when you wrote the laws. I think that would help get rid of some of the things that I've seen in as a land commissioner, and actually some of the things that you see in a lot of the I think the actions of different agencies. There are some things that I think that are out there that I can't talk about the actual details, but some clarity, I think, about when a person, if they lose part of their rights and privileges of a lease, as to whether or not that constitutes losing enough of the rights and privileges of a lease to actually mean that they've lost enough of it to I guess have the legal standing of having lost that lease. And kind of looking into the two straws that I see of property within a lease, one of them is the preferential right, and the other one is the actual lease holding of actually leasing the property for its intended purposes. And from my perspective, I don't think that those can be bifurcated. I think if you take one and don't take the other, you've essentially diminished the lease to the extent that you've actually lost the benefit of that lease. And that's something that in the definition of what it means to lease a land, those are they're separated in that definition, and the preference right isn't part of the definition of the actual lease as far as what it means to have it. So that's something that I think that you should probably take a look at. And if I haven't explained it well enough, I'd certainly offer some time after this on a one-on-one to try to explain it to you without going into the areas that I'm essentially barred from talking about.
Committee, well, we've got the treasurer on the line. Is there anything that comes to mind that you'd like to ask him? It might help to clear up what we're trying to do. Yes. Representative Worf, go ahead.
Yeah, Mr. Chairman, thank you. And Treasurer Meyer, I appreciate you having the I guess, courage to show up. I'm extremely disappointed. I think there's more than just a problem that we didn't follow process. And I'm just mad. I mean, we hear today that you can't talk about stuff. That's why I wanted to have a hearing, Mr. Chairman. This committee should have had the opportunity to call these people in and actually have these questions answered, and to be told that we can't talk about it. How the heck can we fix things when we can't talk about it? And we're being told that we can't have this discussed. They've, I guess, been told not to talk about it, but how do you fix a problem when we can't actually ask the people that were involved with the decision making? And unfortunately, Treasurer Meyer was, in my understanding, is the only one that voted to follow the process. We had a very unique situation where we had a former director of state lands that was now the advisor, the attorney general advising the state land board. And bottom line, we had, and I feel bad, they're not my constituents, but I can tell you, had they been my constituents, I would be even more livid. This is just not fair. We've had a citizen of this state that was wronged. And I tried to get this committee to have a hearing, to actually call these people before us and make them answer us, which is our right and our duty and obligation as elected officials. Now, and believe me, I'm not chewing on you guys. I don't want you guys to feel I'm not mad at you. I just feel like we have a big problem here. And to just say, well, there's nothing we can do, that ship's already sailed. To me, that doesn't work. I think when we have a process, and I can tell you it's tough. We have the 5 statewide elected officials, the most powerful political people in this state, and they're guilty of nothing other than they followed the advice of their attorney. The problem was the attorney happened to be the person that was in charge when this decision was made. And I don't know how else to say it other than I'm just extremely disappointed. I see the family that was impacted is here, and they're still not getting answers. They're being told there's nothing we can do, there's nothing we can say. And as a legislative body, the people that are that are tasked with drafting the legislation, the laws that govern. This to me highlights the problem. And you'll see, I've had a lot of people ask me, well, why would you vote against that bill, Bob? Why would you vote against that bill? And you're going to see anything that gives the power to the agencies to develop rules and regulations. I'm a no vote. I've had it. I think we got to do our due diligence. We're elected to represent the people of the state. And I think we defer too much of that authority to agencies that are unaccountable. And this is a prime example of that, where we trusted them to do the right thing and they didn't do it. And the problem is we're being told we can't talk about it. So by not being able to talk about it, all we can do is say, well, we tried. We're sorry, Mr. Lehman. We're just going to kick the can down the road and, here's some salve. Maybe that'll help it feel a little better, and hope that the next guy that gets it isn't in your district. Because I can tell you, if we're not following the processes that are laid out, I don't even know why we have a state government. If we can come up with rules, regulations that circumvent the law. So with that, Mr. Chairman, that's not much of a question. It's just, I guess, it's why I asked to have a hearing. And out of respect for this committee, I decided to follow what we decided we wanted to do as a body. But I can tell you, I don't think we've resolved this. And I appreciate Treasurer Meyer, but I guess that's the question I have, Treasurer Meyer, is how do we fix things when we can't talk about it? When we're told you guys can't discuss it, how do we fix problems that we can't talk about?
Yeah, well, Mr. Chairman, I think that the reason I can't opine on some, and it's not the Lehman matter, it's another matter, that it's essentially it's in the court of law right now, and those are things that we were said that, if it's before the OAH or if it's in past that those are things that we don't discuss. And I think it's mostly from the standpoint of limiting liability to the state. Because you guys know me, I could probably say something that would increase the liability to the state. And so those are things that they try to protect us, I guess, from ourselves. There's another matter that I want you to take a look at that doesn't involve state lands, but does involve, the Office of State Lands, but does involve the leasing of lands. And that's the leasing of lands around the Guernsey National Guard area. And I don't know if you know what's gone up around in that area, but a few years ago, essentially one person leased up most of the lands, and primarily from the process in which they developed was that they there was more weight given to how a person prepared a grazing plan than the actual ability of a person who'd been grazing that land for 20 years and actually implemented a good grazing plan. And it was a new process that was drawn up, and essentially it had some very devastating impacts on people that, as I say, had been running on that land and actually owned some of that land, had been given an assurance that essentially as long as the rivers flowed and the grass was green and there were rocks on the ground, that they would have that land. And essentially that all kind of went backwards on some of those folks. So that's something that I think you need to pay attention to, and maybe develop some new statutes about how that land is leased around there. The long and short of it is that the person that leased all of it is in a big bankruptcy, and that outfit owes I think both Guernsey and the state grazing fees now. But so that's all kind of blown up. But I'm assuming that the Guard's going to be releasing those lands, and they don't have any statutory guidance at all about that process. So that's something to I guess put on your table and consider. There's other things in there that seem like all all temporary leases are not considered leases. And a lot of times temporary leases will go on and on and on, but there might be some type of a thing that after so many years, a temporary lease has the same rights and privileges as a real lease, you know, but you know, those are some discussions. I'm not giving you any guidance on that, but it seems like there's some areas there that are ripe for some discussions, and areas that could have some problems down the road. And yeah, I think I recall I was in Mr. Lehman's camp at the time, and necessarily probably still am, but there's I guess the thing is, guys, I go back to it, is that take one day to go back in and actually go through the rules with a fine-tooth comb. I know that from time to time, I know committees have said, well, we've got rules. Has everybody read them? Oh yeah. Oh, is everybody all right with them? Oh yeah. But the other thing that can happen, if you find something that's not right, the governor does have veto authority to go in and line item veto those rules. And so I don't think it's ever been used to much degree or extent, but there is that optionality to you too. So yeah, I think those were a lot of the things where I thought that you guys might have a hand in writing some new statutes. And there's some areas up there that we have continued problems in that Jackson Hole area, that you might take a closer look at that and see if there's anything there that we could uniformly apply across the state that wouldn't get us in trouble. But that's another area where I know there's going to be continued I think discourse into the land use plans up there. And essentially, I don't want to have the states have their hands tied by local government, but in some circumstances and certain uses, I think that it probably would be a good idea to have the local governments have some at least advisory status, if nothing else.
Thank you, Mr. Treasurer. Before I take a couple more comments and questions from the committee, are you okay? You're traveling and you're in some meetings. You can visit with us for a bit more?
Yeah, I'll take that time, Mr. Chairman. And, you know, I'm not sure what I'm missing, but I'll have somebody tell me what I missed on when I get back to the meeting.
All right. Thank you, Mr. Treasurer. Representative Heiner.
Thank you, Mr. Chairman. Mr. Treasurer, thank you for being here with us this morning. From the limited knowledge that we have of the events that with the Lehman transaction and the state lands and the board and everything, it appears that there were some mistakes made, and some of our citizens of Wyoming were treated unfairly. From your capacity and your role as one of the top 5 executives, is there anything we can do to resolve this and make it right with those individuals that were hurt or damaged because of the actions of the state? Is there a way that we could take that land in question and put it into the rightful people for grazing rights and fix these problems that were caused by these mistakes, whether it was through bad counsel or other reasons? We need to try and do what's right. That's what integrity is doing what's right when we make mistakes.
Yeah. You know, I'd have to go back in and revisit the details before I'd give you any counsel on that. But that does bring up something that I know that we've been looking at, and Jim McGagnes has brought forth some different options that may allow us to fix some of these things, and that kind of happened because some of these COVID leases that didn't get in on time and at the proper time and different things. And that's to talk about if somebody gets I guess afoul of the rules and regulations in which they lease that land, a way to I guess mend that deficiency or correct it, and before the end of the lease. And if they did that before the end of the term of the lease, that they wouldn't lose their preference rights or the ability to release that land. And so that's something I think that has some merit. You want to have it tight enough that it isn't abused, and get into the some areas that if people do abuse it, you might let them do it once, but then if they do the same thing 10 years from now, then it's kind of like, okay, well, but I think that might help on some of these areas there. It's I think there's a possibility that you could have some situations where say somebody was using the land just to cross it to go from one pasture to another, and that's necessarily a temporary use, and another person was using it for grazing primarily, that maybe you could put some corner gate panels in there and allow people to use that as a temporary crossing, but still not interfere with what would be a primary use to an operator, which would be the grazing. So I think that you can have two uses on the same piece of land, one temporary and one permanent, provided you put in all the safeguards that would allow that those cattle to trail across the property, but do so in a small restricted area that would still keep the grazing available. So there's some like specific circumstances where I think you can find some compromises, and I'm not sure whether or not we have that ability within the statute or the rules and regulations to allow that to allow both those uses on the same piece of property. But Jason or may be able to enlighten us on that, because we may be able to do that. But I think that I think there's some areas where people want to get across a piece of land, but the guy grazing it doesn't want them to stand there for 3 days and eat all the grass and then go across it. So.
Thank you, Mr. Treasurer. So a couple of things that I'd like to say. This committee has talked pretty freely about what happened, and we've tried to gather information. It's been pretty public. Anyone who wanted to listen in on these meetings could.
Mm-hmm.
So that part, I don't remember ever being told, don't talk about this or don't talk about that as a committee.
Yeah.
And
it's a total different issue that I can't talk about. Yeah, not this.
I know.
One. Yeah.
Yeah. Follow up, Senator Boner.
And Mr. Chairman, just to be clear, Treasurer Meyer, there's nothing the legislature can do or is there to compel you to divulge that information outside the session or anything like that. There's no, if we subpoenaed you, for example, that wouldn't change your ability to divulge that information, would it?
Well, I think, if it was an executive committee, then I'd ask counsel. I think you could probably do it in an executive session. I'm not sure when that particular issue is going to be decided. It may have already been decided by OAH. I don't know. I'll have to, I'd have to look. So why don't we talk about that when I get back from DC here, and we'll see what we can do, Brian, to try, let you guys be as informed as you can be. The thing is that you can't write any ex post facto laws, which means you can't put the toothpaste back in the tube. Once you have a legal decision, you can't rewrite the laws to get a different legal decision. That's not the way our court system works. So that's the frustrating thing about it. You can be proactive and look at different preferential areas, or if other pieces of land or something come up for whatever reason, you know, that's a possibility that that somebody might look at if they're going into some kind of a settlement agreement.
Thank you, Mr. Treasurer, and we'll be working on some statutes today that hopefully clarify the law and make this easier. I'm not sure what state lands could do in like a dual leasing of a certain property. That's a good suggestion, but I think it's kind of hard to do too.
Yeah.
Anyway, I do appreciate your time here. We'll be in touch. We're going to work on some legislation that we think will be proactive in going forward. I guess I would remind the committee that the Lehman case was something that happened several years back. It was a different administration. There was a different director, a whole different ag committee. So a lot of what happened wasn't the fault of anybody here. And that also adds to what we can do about it. But we have talked quite openly about what happened. My hope is from here on forward, we can find remedies that prevent this from happening again. And that's Representative Fortner.
Thank you, Mr. Chairman. It looks to me like the problem's pretty obvious. We got the 5 elected officials, the inner circle of the governor, and I don't know if I'm supposed to say that or not, but anyways, that's the way I feel about it. If we move away from that process and move it into a jury trial, what does it take to do that? Is that a constitutional amendment to do that, or is that something that we can codify in a new statute? That looks to me like the problem exists right there in that little window. If we can fix that, I think we have everything cleaned up. We have accountability back to the people at a jury trial where it belongs. Thank you.
I
Chairman Bowman.
can certainly stand corrected by the director, but that is an option at the end. You can always appeal the board's decision to the district court, I believe. So that process does exist currently in statute. Now, if you disagree with the board's decision, you could always, that process is there. Now, whether it's used or not, I don't know. That'd be a good question. Whether it's too high a bar, if there's something else we could do, I don't know. But I think the director will probably be able to provide additional clarity if I misspoke or didn't provide sufficient detail.
Mr. Chairman, Mr. Co-Chairman, Representative Fortner. Yes, the way this process works is once the director's decision has been issued, the party, the Lehmans in this case, could appeal that. That was appealed to before it goes to the board. The board doesn't act as an adjudicatory body where it takes in the evidence. They assign that to the Office of Administrative Hearings. They hold the factual hearing, if you will, and then they make a recommended decision to the board, and the board is free to take that or not take that. Once the board issues its decision, then the applicants are free to appeal that to the district court, and that was not done in this case. So.
Yeah, Mr. Chairman, if I may.
Go ahead, Treasurer.
You know, one of the things that I've always seen in government is that you can never afford to sue the government because they don't have to pay for their attorneys. And it'd be interesting, and I don't know if you guys are even up for this concept, to have a concept that the government would have to pay the plaintiffs' attorneys if it would actually found out that they were wrong, because believe me, it is an uphill battle, because as I say that all through the court system, that the deference is to the agencies and to the government, as far as them having all the experts and they're being right in the first place. But we all know from time to time the government does make mistakes, but the cost of going to that and proving that is you might be rewarded that the day after you win, the agency goes in and makes a decision that's almost exactly the same, has the same results, but you have to be right back in court. And so I think maybe maybe having the state pick up the other side's court fees if the state isn't proven right might balance that out. But that could get us into the need of probably another 15 more district courts. So it is a balance from time to time, but it is frustrating to know that you're always going in and with the preference and deference against you, and when you walk out, and I've seen this in water cases that people just they give up before they start because the state engineer can just make another decision the day after, and essentially doing the same thing, and you're all right back on the same merry-go-round. So it's kind of frustrating, but it's still the best system in the world. But if you guys can make it better, more power to you.
Thank you, Mr. Treasurer. A question I'd have the director on this. What is the time limit on this appeal process? That it was kind of the last part of the process Lehman's didn't do. Part of the frustration we have is that they jumped through every hoop up to that point. How much time would they have had to have appealed this, and would it benefit grazers to have a longer period of time to be able to appeal?
Mr. Chairman, I believe that once the board issues its decision, it's 30 days to appeal to the district court. And that's standard, I think, under the Administrative Procedure Act, the Wyoming Administrative Procedure Act.
Okay, thank you. All right. Representative Heiner.
Thank you, Mr. Chairman. Mr. Chairman, I saw on the earlier agenda that the Attorney General was on the agenda to be here to discuss any questions that this committee would have. Was the Attorney General invited or asked to be here and we were turned down as a legislator? So do we have the right to subpoena the Attorney General and force the Attorney General to answer to this committee? It seems like we should have the right to ask questions, and if these individuals that are government officials, if they don't respect this committee and don't come to answer those questions, we should have some recourse to force them to come.
Brian, go ahead.
Yeah, Mr. Chairman, yeah, that's, I believe a standing committee does have that power. It can be corrected by our staff. Not sure the last time it was actually used, but I believe that is in statute. I believe it's a majority, simple majority of the committee. So that is an option. Another option would be simply to, write a letter or whatever the case may be, asking some questions if we have them of the Attorney General. And yeah, so there's a couple of different options there, but yes, to be clear, we did invite the Attorney General and she declined.
Mr. Chairman. Mr. Chairman.
Thank you, Mr. Chairman. It seems like we should have some respect from our officials and for this committee. We are representatives of the citizens of Wyoming, and when we have questions, we should have a right to know. And so if the Attorney General refuses to come to answer those questions, we should have a way of compelling that, because we campaign on this transparency issues. And if our Attorney General's office doesn't allow us to have that transparency, it appears like there's been something hid here. We have a right to know. We, as representatives of our citizens, we should be able to ask those questions.
Mr. Chairman. Mr. Chairman.
Representative Blackburn.
Representative Heiner, I think that's what we tried to do a couple of meetings ago when Representative Wharf tried to have the hearings, and whatever happened to that, it got thrown in the trash, or we just decided not to do it. Somebody decided that we shouldn't do it after we all voted to do it. That would have started the ball rolling, but we didn't want to roll the ball. So that's where that went. So I guess next session, since you'll be in office, that'll be your task.
Whoops, here, I better, okay, Representative Wharf.
Yeah, Mr. Chairman, I guess 2 points. I do want to thank Treasurer Meyer for clarifying that when he said he couldn't talk about it, he wasn't talking specifically about the Lehman case. That was the case. That's the one that I wanted to have the hearing about, and that's what I thought we were referencing. So I do appreciate him adding clarity to the fact that that's not what he was being quiet about. But I want to ask, was there any messages that were sent out that told people from the State Land Board not to be here at this meeting?
Mr. Treasurer, did you have something to add? Looks like it.
Oh, I was just saying, I just want to thank you guys for the opportunity to share my views, and I was going to sign off. And I think the response to Mr. Ward's question, or Representative Ward's question, is that was, I think that was a recommendation of council that we kind of stay put. So I hope I didn't step on too many fingers, toes, and hands today, but I hope you guys found that some of the things might be that I mentioned might be constructive. So
thank you, Mr. Treasurer, for coming. We appreciate it. Hope your meetings go well, and we'll see you before long at the Capitol.
you bet.
Thank you much.
Have a good one. Have a great Thanksgiving, folks. See ya.
Okay. So I think we're gonna probably open it up for public comment.
Secretary Alman's here.
Oh,
Yeah.
okay. Acting Secretary Allred. Did you have anything you wanted to bring to us this morning? Not in this.
On the board, at the time that decision was made, so I can't
Yeah,
speak to that.
yes. Yes, go ahead, Representative Heiner.
Thank you, Mr. Chairman. Mr. Secretary, Acting Secretary, were you advised not to come to this meeting by council beforehand, or as this treasurer mentioned, he was advised by council that this is something that they shouldn't show up to? Were you advised as well?
Mr. Chairman, Representative Heiner, yes, I received that same advice.
Go ahead.
And can you be a little more specific what that advice was?
That, as close as I can recall, the letter said that they knew that I was invited to come to this meeting, and the advice was not to come.
Thank you. Appreciate your being here.
Thank you, Mr. Chairman.
Oh, we've got another question here. Representative Heiner.
Thank you.
No, not Mr. Portner. I'm sorry.
Thank you, Mr.
Bill.
Chairman. Can you tell us what the reason for that was to advise you not to come?
Mr. Chairman, Representative Fortner, I do not know what the reason was. It didn't go into detail. That was about the extent of the email.
Representative Heiner.
And Mr. Allred, who sent that email?
Mr. Chairman, Representative Heiner, it came from the AG's office.
All right. Thank you, sir. All right, do we have any further public comment? Yes, Mrs. Lehman, come on up.
Mr. Chairman Eklund and Mr. Co-Chairman, Mr. Boner and committee. Since it was brought up that the Lehmans did not appeal that case to the district court, I'm not familiar of how many of you know the appeal process, but how they look at that is how we were under the impression, in my understanding as well. When you appeal that particular order, it is only based off of whether or not the board looked at all the findings and facts of the case itself and hit on those pieces and didn't ignore them. Whether their interpretation of the findings and facts or whatnot is not necessarily looked at as whether they did that right or wrong necessarily. It's whether or not they hit on that, and that the board itself has the authority over an agency to make its own decisions. And so if we were to appeal that, we would not reopen up all the facts and evidence of that case to be heard in front of that judge. It would just whether or not they issued the order looking at those things. And they have the right as a board to make their own decision over the agency. And in this case was the former director acting as the current AG. And so that is an issue within itself, but that with that said is why it's up to whether or not this particular committee wants to look at when there are facts and evidence and testimony brought forward through the OAH hearing process, that whether or not you would like to be able to, when there is a contest, content where we then are the citizens are wronged by that, how you want to look at that in this case, which was not afforded in the two that came after us. We were treated differently because we were not allowed any public comment when that order was issued. And it was the first time that the SLIB board had the in on Zoom because of COVID. They met, and so we weren't even allowed to be in person, but we were by Zoom, our attorney as well. And then our attorney was not even afforded to see that order drafted prior to the hearing. And so we didn't see it until after it was read. And that particular situation, the current sitting director for the Office of State Lands actually yielded her position on the floor to the current AG, who was the former director, and had a person come in as her, that is an assistant AG that sat there with the order and read it, and then they went with their motions off of that. And the reason why that's disturbing is because the OAH is the one that heard all the facts, findings, and all the evidence and testimony, and the SLIB board does not. And so what it does essentially is, if that does happen that way, it cuts off that information feed to the SLIB board members per se, given their huge amount of task of different cases to hear. And so with that, something you can maybe do, since you're the legislative branch of the three branches of office, is to listen to the citizens that are wronged and to look at how you could readdress that issue of when something like this happens, because those members are actually listening to someone interpreting and reading those, the recommended order from the OAH, and giving a brief synopsis, like a Cliff Notes version to those 5 electeds, to then say why they draft this new findings of facts and conclusions of law to support their order. You know, they need to have something that doesn't cut them off from the information chain, you know, because I think in this case, maybe not all of them fully understood is what I would prefer to believe, because there was a lot of evidence came out in that case that was very disturbing of how the OSLI was conducting its office. So I just wanted to bring that forward as to why it wasn't appealed. And there is a, you know, appellate's procedures that oversees those kinds of things. And that's a different thing, since the SLIB board oversees the agency. So anyways, thanks.
Yeah, hang on, Mrs. Lehman, hang on.
Okay. So we heard a suggestion as far as being reimbursed for your attorney's fees if you prevail against the state. Would that have helped in your situation?
Well, sure. I mean, we're just a small private,
right,
you know, small business. Absolutely, because we were wronged. Because what our case showed is there was a private public partnership, and the whole reason why the prevailing side got it is they had these TUPs as a model that they were afforded an opportunity with the OSLI that we were not given when we were really the only adjoining landowner for 8 to 9 years. And then when this particular entity finally got to acquire a sliver next to it, all of a sudden it was up to be able to look at that vacant lease. Then all of a sudden they had manpower to do that. They acquired that at the end of 2017, and then 2018 that January sent out the notice that, oh, okay, we were interested in having those vacant leases applied for. So are you still interested? Of course we were, but at the time we were wronged because we were the only one interested. It was fenced in with the land that we had, and my husband was very diligent as a respectable citizen, saying, our cows are running on your lease, and what can we do to right that? Because that's not, a good way of doing business in our book, anyways. And so, and every year we were told that no, there's a process, and we just don't have the manpower to go out there and do it, or whatever, or they were going to do it in the very beginning, and then agencies change heads, they changed, and then it got lost in the shuffle. And then it wasn't until the case comes to where we lose the application process as not the prevailing bidder that then we then discovered there were these TUPs that were issued. And reason why that's important is the particular TUP encompassed 2 leases, 1-8820, 1-8710, which 8710 was the one we were interested in. And the 8820 and the 8710 were at one time owned, leased by the same person who let them go vacant, and then sold the land that encompassed the 8820 to Wagon Hound, and then the one that encompassed 8710 to us. And then Wagon Hound devised this TUP to have both those leases. And just because they turned those cows out on the 8820, they then did not violate technically a TUP, which the testimony shows that with Mr. Heiser as the attorney presenting that with a chuckle. And so when you apply for a TUP and you wrap those 2 leases in there, they didn't turn a cow 1 on the 8710. We on the ground never saw that, in fact, Wagon Hound had any access or interest in 8710, nor much less had a TP, and saying that they were actually in need of it and using it in order to apply for that every year. And they never did turn a cow 1 ever on that. It was never fenced in with them. It was fenced in with us. So those are the issues that were happening in the OSLI that have yet to ever be remedied. Since then, they've now come in with a half-mile fence and grabbed that lease out of the land that we have. And those cows invariably, whenever they put them in there, are stuck in there with no water because the water is on our land and it just doesn't flow right. I mean, that's the whole reason why it was done that way to begin with. And either you care about range management or you don't. But anyways, just thought I'd tell you that. Okay.
Representative Heiner, that was a very good condensation of some of what happened. In case you're wondering what the TUP is, it's a temporary use permit. And I had forgotten there were 2 of those. But anyway, that was very interesting. And
which isn't typically done on just ag land. Usually when you have like oil and gas or something, but on ag land, it's not typical. And that's in the testimony too by Jason Crowder.
Okay, thank you. Representative Heiner.
Thank you, Mr. Chairman. Mrs. Lehman, thank you for being here. I've heard comments from other individuals that part of the problem is lack of communication from the Office of State Lands, and I've experienced that myself. During your ordeal that you went through for a number of years, was the lack of communication a factor in the confusion and problems that you had?
My husband would be the better person to ask that too, because he's the one that talked to the Office of State Lands regularly. So I'll yield for him to answer that.
Go ahead, Mr. Lehman, when you're ready. Thank you, ma'am.
Chairman Eklund, Chairman Boner, Representative Heiner. There was the perspective of lack of communication. I was told one thing at the onset when I inquired about the leases that had been vacant up to 10 years before I started inquiring about it. And it was made very clear to me by the office that there was a process. That they had to inspect them, they had to advertise them, and then I would be able to get an application. But they just didn't have the manpower to get that done because vacant leases weren't a priority. I said, okay, so I tested that process theory, so to speak. I said, well, given that the previous landowner who had been assigned that lease failed to make those payments, and now I'm the current landowner of those deeded lands in which this lease is fenced, how about I make those annual payments to you, just get it all caught up so we're good to go. And it was made very clear, no, Mr. Lehman, there's a process. We have to inspect them, we have to advertise them, and then and only then will you get an application. No ands or buts about it. But we don't know when we're going to get to it. It might be the next year. I said, okay. You have a file in your office. It shows that this lease has been historically assigned for the last 70 years to the land that I currently own and control. That's just the way that, based upon the fencing configuration. And my livestock are most likely going to be wandering on that state piece that's fenced in with the deeded lands that I now own and control. I was very transparent with them about that. They didn't seem to mind that. They didn't care about that. And when the next year come around and nothing was done, I'd call down there. I said, well, when are you going to engage in your process? When are you going to get inspection and advertisement so that I can apply for this? Oh, I just don't know when I'm going to get to it. I just don't have the manpower. And this went on for 8 years. I was totally dismissed, and I had no idea that this office, when they're telling me one thing, we just don't have the manpower, we don't have the resources, they willfully and purposefully developed this model. And this is a testimony. They assisted, this is a quote, they assisted Wang and Hound Land and Livestock in creating a model whereby they would issue this temporary use permit, which according to Deputy Director Crowder, they shouldn't be issuing temporary use permits for the purpose of grazing, but they did it anyway. And they included not one, but 2 independent vacant leases in that TUP. And they had the resources and they had the manpower and they had the ability to make that happen, but they did not have the manpower, the resources to do the job with which they were charged as the written rules, policies, procedures outline. And that was very disturbing to me. You can do one thing and not do anything for what I'm saying, asking you to do. And they don't have a problem with that.
Representative Heiner.
Thank you, Mr. Chairman. Mr. Lehman, with your communication, did you initiate most of those communications or were they initiated from the Office of State?
I did. And when I made that initial contact, I remember I spoke with gal down there. And we had some more email correspondence and she did make a note to me. She said, well, thank you for your inquiry. And because you've inquired about these leases, and at that point, both of them were available. She said, your name will be on file. And if anything happens to these leases, you will be notified. It was interesting when we started going through this OAH hearing process, that when I went down there and looked at that file, there's not a single reference to me in that file, nothing. I'm able to supply the correspondence, certainly email. There's not a single reference to me in that.
Thank you, committee. Thank you, Mr. Lehman. All right, go ahead.
No, is that all? Any other
I
questions?
think-
I guess the only thing I would say is that if this office wants to have the latitude, if the Office of State Lands and Investments wants to have the latitude to engage in a whole host of unwritten policies and procedures and have that purview to do that, then maybe you better make it available to everybody. When I asked, what are the disturbing things when the Attorney General's office, who represented the Office of State Lands and Investments, it got to the point where the attorney was accusing me of being the trespasser, of being the violator, the bad actor in this thing. And I said, well, with all due respect, because I didn't have the proper permit. It's like, well, excuse me, with all due respect, where is it in the rules, written rules, policies, procedures that you have to have a temporary use permit for grazing? And the office said, well, you won't find it there because it isn't in the written rules. Why is it? Well, because it's part of our unwritten policy. Well, how am I supposed to know about that? Well, you wouldn't. So if you're not going to be transparent, if you're going to extend this kind of preferential treatment to certain people and not extend it to others, that's bad business. Especially when I'm really trying to engage the office in doing the job with which they're charged. And I can understand there's a lot of information that comes before the Office of State Lands and Investments, a lot of issues. And this, how this could fall through the cracks. But that's why you have the process of administrative hearings. When you have an agency that's gone off the rails here, if you have a citizen that takes the time, the effort, and spends the resources, thousands of dollars to accentuate this and say, hey, we've got an issue here, we've got a problem here, then that's where this office and that's where this slip board's got to sit up in their chair and say, oh boy, we got a citizen who's taken the time to go through our process about an issue that we have with a state agency. You better take it seriously. You don't just throw it under the bus and say, oh, well, there's not much to see here. It's an issue. It's a big problem because these decisions are affecting people's livelihoods out here, especially when you're out there trying to follow the rules and policies as they're written. They mean something to people out here that are trying to it because, by gosh, it's like there's a two-tiered system. We're going to extend certain policies and procedures to certain people, and the rest of you got to follow a whole set of others. That's got to stop. These things, you use legislatures, you spend your time drafting legislation on the part of the citizens. And it's the responsibility of these agencies to draft the rules and the policies and the procedures and how they're going to implement, administer, and ultimately enforce them. And if they're not going to do that, well, we're wasting our time. We really are.
Mr. Lehman, we're hoping that as we go into the new draft bills and the legislation going forward, that will correct some of these problems. And it's our hope that we'll also be involved in the rulemaking process to prevent this from happening to another person. And that we'll be proactive in cases that are going to come after it. And I think that's the hope of the whole committee. Go ahead.
Thank you, Mr. Chairman. One other comment, I would maybe suggestion is that in a situation like this, which makes this situation unique, is the fact that when you have a former director who now is then appointed to become the Attorney General by a sitting board member, in this case by Governor Gordon, appointed Bridget Hill now to become the Attorney General. And that agency's responsibilities, the AG's office is there. One of their functions is to represent the Office of State Lands and Investments or agencies and advise the SLIB board. That creates a major conflict of interest. It really does, because you have an agency who by virtue has the authority to basically justify, in this case, her own actions. That an independent, impartial counsel, the OAH, said, we got some major problems here. That creates an issue. So one of the recommendations I would say is you can't have that kind of thing. If you've got a former director of an agency or working as employee in an agency, in that they really cannot be in a position otherwise to exert some sort of authority that circumvents or justifies what they did as a former employee of a state agency, because that really creates an issue here. And I think that's one of the reasons we're seeing some of this pushback right now. It's unfortunately, but I think that would be one of the things that you want to put a roadblock into that from that happening.
I agree, and I'm hoping that we'll be able to do some of that in the legislation forward. I'm not sure but what it's going to come with rules, but I agree with you. There needs to be some checks and balances that avoids any kind of abuse by the state of Wyoming.
Yes, sir. And Chairman Boyd, really, if everything was up and up, there is no reason why every single SLIB board member should not have been able to make themselves available today, or at least through some sort of letter or correspondence, or even Attorney General. These are elected representatives. And by virtue of being elected or even appointed, they derive their power from the electorate, the people. Period.
Chairman, you have something to say? Go ahead.
Right, yeah, and I have to say I'm disappointed, especially the Attorney General didn't show, and I just learned along with everybody else, they sent that advice to the board, so I do appreciate that coming to light in this committee, and we do have members of the board here. It's been common practice that, if you invite the Board of Land Commissioners to be here, if you get two or three, that's actually pretty good. So whatever the committee wants to do with that, and also recognize the fact that we've had a lot of turnover on that board. And, Secretary Albright's a perfect example of somebody who was not there. And unfortunately, two of those members, I believe, and correct me if I'm wrong, Mr. Lehman, are no longer in their positions in the Ohio State or in the separate branch of government. So that's why what I was hoping to get out of this was learning about the process. And yeah, that's a big question. Why does not the AG recuse herself or take a step back, have somebody else take? I mean, these things you have to be able to do that, because these things will come up from time to time. So yeah, committee. We do find ourselves in I guess if we want the AG here, that's something we could really force if we want to. I know that we have a lot of information as far as the Lehman matter, and I feel like we've got some good bill drafts going once again to prevent it from happening again. Maybe we have another one that we heard today from Treasurer Meyer that might be useful as far as attorney's fees. Of course, there's probably going to be lots of consequences to that, but we'd have to take an even-handed approach. But that could be another alternative for sure. Because I imagine if I remember correctly, it's about 130 something odd acres, right? This lease.
He has about 139 acres.
And
Yeah.
and at some point, thousands of worth of attorney's fees doesn't make it worth it. Right? I mean, so
Correct.
you have to make that realistically. We can have that process in place, but is it accessible to citizens? That's the question. So, anyways, I think I had a question there. I guess I don't, Mr. Lehman, but so that's I think where we're at right now. Like I said, we have lots of bill drafts meant to be proactive. We had one that passed after a governor's veto that dealt with the challenges with vacant leases that provide some clarity, and maybe there's still some work to do for sure. But anyways, so I appreciate your continued testimony, Mr. Lehman. I'm sorry that this process did not work the way that I think any of us wanted it to in this case. And it is tough. And I think it's important that we hear this testimony committee because this does impact people. I mean, it does impact our citizens, their livelihoods. And I think that's a question we have in general with this and a few other situations. Is it just as simple as, whatever entity wants to come in and throw as much money down as possible. And that's going to be enough to compel the state to give them the lease or whatever the case may be. And is that really what we intended, that our framers of the Constitution envisioned in 1890 when they set our Constitution into place? So yes, I don't exactly have a question, Mr. Chairman, but once again, appreciate your continued diligence. And I think it is important that the committee be reminded of the importance of this agency and the impact it has on our citizens.
Thank you, Representative Eklund and Senator Boner. Chairman, appreciate your time and the committee really, because this is something that we really need to pay attention to. We really do. We really do.
Thank you, Mr. Chairman. Good day to you, sir. I'm drinking from a fire hose here, trying to understand this long ordeal you went through. But I did have a question about the ruling. So did you, in fact, disagree with the findings of facts on the ruling that the state had made on the determination? Or did you, or I heard some things that sounded like you didn't challenge the findings of facts. And I just, for I guess, clarity's sake, could you explain your position on that, on the decision that came down? Do you agree or not agree with that decision, and as per the findings of facts?
Chairman Eklund, Senator Cole, our issue was somewhat multifold that we brought forth. We looked at the first thing we looked at was it states in the rules that if an applicant provides false information on a board approved form, whether it be for a 10-year lease assignment or for a TUP that is determined to be material, that it shall be rejected. And one of the issues that we had was Wagon Hound was intentionally providing false information. That was a fact that came out from the case. They said that they needed the TUP for grazing, that they would fence it if necessary. They supplied maps saying that the lease of which we were interested, the 1-87, was indeed fenced in with them. There's no way of looking around. That was a false information, period. And there's rules in there to say, if you do that, it's going to be rejected. The office's position was, Office of State Lands was, well, that's immaterial. Doesn't mean anything because it was a temporary use permit. The position of the slip board, the way I understand it, was that, well, it was in their mind, it was the temporary use permit. It had no bearing on this case, on the 10-year lease assignment that was issued by the director at that time. And so we had no credence. The other fact was, well, you shouldn't be issuing temporary use permits for grazing. I mean, it's specifically clear. Mr. Crowder, Deputy Director Crowder, said, yeah, we shouldn't be issuing temporary use permits for the purpose of grazing. Actually, the rules say we shouldn't be doing that. Well, this office did it anyway. They only not only issued one, but they issued one temporary use permit, included 2 independent vacant leases. You shouldn't be doing that. And the slip board's findings of fact conclusion, well, that's just immaterial. It's TUP, it doesn't mean anything. And our position is, well, it does. It all led up to where we were, why we brought this forward in the first place. Had the office done its job when we were asking about it, and because we were the only qualified applicant at the time, Mr. Corbett was the other qualified applicant at that time, the only 2 adjoining landowners at that time during that 8-year period who were qualified to lease that land because of the adjoining land configuration that both of us had. By the fact of the office engaging in this TUP process with the Wagon Hound, denied us the very opportunity to engage in the process as the written rules, policies, and procedures outline. On an annual basis, we were not even allowed to participate in the process because they didn't have the time and the resources to get it done. But yet they certainly had the time and resources to do the TUP on an annual basis for Wagon Hound. Extend that preferential treatment to Wagon Hound and pretty much dismiss myself and the other qualified landowner. That's an issue because that goes at the heart of what the rules and the policies, the procedures state in the statute when it comes to leasing vacant lands. So to say that it's immaterial, I'm not going to agree with that, nor did our attorney. And obviously the hearing examiner, the independent, impartial process that we're citizens are supposed to go through, they didn't agree with that. Now, if we had gone through that process and the OAH came back after listening to all the facts, hearing all the evidence, says, gosh, I can't find anything in here, Mr. Lehman, where Wagon Hound or the office acted outside their authority or violated anything. And therefore, I'm just going to have to go ahead and recommend that we uphold Director Hill's decision. I wouldn't be here talking to you today, most likely, because I wouldn't have a leg to stand on. But that isn't what happened. Everybody had the opportunity, all the agencies, all the people involved in this had the opportunity in that independent forum, the OAH, their process, where you have citizens that has a grievance with the state agency to state their case, present their facts, their evidence as to why they did what they did. And everybody had that opportunity, and they did. Hearing examiner took over a month, looked through the statute, looked through the rules, policies, procedures, and came up with a recommended order based upon the findings of fact, conclusions of law. And it was what it was. It was disturbing. And I remember Mr. Gordon coming out, Governor Gordon coming out, looked him in the eye, shook my hand and said, thank you, Mr. Lehman, for going through the process. There are a lot of unanswered questions, unquote. Yes, there were a lot of unanswered questions. And I went through the process, Governor Gordon. And yes, the answers to those questions are pretty disturbing, but they are what they are. And I went through your process. And it is what it is. The fact is, this little hayseed up in Converse County won. And by God, exposes some things that should have went on, in the words of Deputy Director Crowder, quote, should have never gone on as long as it had, unquote, but they did. And when you then, we've gone through it before, if you have then someone who's trying to justify that action, it's not even willing to show up today. If it's all up and up, why not? Justify why you did what you did. I'm just trying to get clarity, transparency. That's what it's all about. Period. So that's why, if hope I have answered your questions, why we disagreed with that.
Thanks.
Yeah.
But
But
thank
you
you.
did agree with the hearing examiner and their decision. They're sided with you as I understood it, correct? The hearing examiners, and I thought that was your. Oh, is that me? Making the noise?
Chairman Eklund, yes, that's correct. After going through that process, presenting all the facts, evidence of the case, the office had the opportunity to do it. Wagon Land and Livestock had to do it, and we did. And after all that was presented and discernment on the part of the hearing examiner, she came up with a recommended order that the conditional award of that lease that was initially awarded to Wagon Hound by Bridget Hill was not going to uphold. She wanted to see that it was assigned to us based upon all the nefarious activity that was going on. Yes.
That's part of the frustration and the confusion that's happened in this whole case. And why, as much as we can, we're gonna try to fix it in statute or rules somehow. So it doesn't happen.
Chairman Eklund, that's exactly right. If the representatives of the powers to be expect citizens to go through a process, and I remember Chairman Boner making that comment, I said, well, you know, thanks, John, you're crossing the i's and dotting the t's here, or crossing the t's, dotting the i's here. You're going through a process. You know, it doesn't do me any good as a committee or you folks just to start ranting and raving on stuff, but we went through a formal process that's available to us as citizens. We got a problem with an agency. And if it's going to be just totally dismissed because we have a slip board that's going on the advisement of a former director of the state lands, who's now the attorney general, I mean, there's a real issue there. That's a real issue. You citizens now are not being availed due process as it was designed. The whole system is flawed if you allow that to kind of happen. And that's wrong. And with all due respect, Bridget Hill, you now as Attorney General, the office of the court, you should know better than that. Period.
We agree.
But see,
And
this,
we've
and
got-
I understand you guys are frustrated a little bit, but this hand wring and say, well, there's nothing we can do. This thing could be corrected right here and now by the powers to be and say, you know what? That's the mark of a true leader. A true leader is to say, you know what? We screwed up. And we have a citizen that took the time, the effort, the resource to come in here and bring this to our attention. We're going to make this right. Period. That's the mark of a true leader. But if you're trying to whitewash stuff and throw someone else on the bus because you've got some other political motivation or whatever, that's what's the problem in this country. Now, this, unfortunately, the state of Wyoming is a microcosm of that. We can't tolerate that if we want to save this republic. Honest to Pete. We've got to get, you can have the most honorable, best legislation, rules, policies, procedures, but if you don't have honorable, decent people in there who are willing to administer, implement, and enforce it, we're all wasting our time. And I don't mean to be mad at you folks. It's just the frustration of this gosh darn thing. People have got to be held accountable for what they did or did not do. Period.
Agreed. Thank you. sir.
Thank you, Chairman
All right.
Eklund, Chairman Warner, members of the committee.
So,
Anything else?
no.
All right.
Let's go ahead and we're going to move on a bit more. Any other public comment? Okay. The next, yes, sir. Come on up. Senator-elect, Mr. Ide.
Thank you, Chairman Eklund, Chairman Boner, members of the committee. My name is Bob Ide. Good discussion today, good questions. I learned a lot more than I did last time from this session. The one thing that is not answered yet that keeps going through my head and what's sitting back there is what can this body do, this committee, to, you know, I don't know what the right word is, reprimand the conflict of interest with the former state land director and now the AG. You know, the comments have all been, there's no way to reverse anything effectively at this point, but what can you do to wrong right that wrong that is obviously a huge conflict of interest the way she ruled on that.
Representative Worf.
Thank you, Mr. Chairman. Senator-elect Ide, there is a remedy and I tried to do it. This body passed. I made the motion to hold a hearing. It was passed by this body and it was ignored. Okay. And there's no two ways around it. It should have happened the last meeting. We were asked not to do that. And out of respect to the chairman, I deferred to them. But having done the way we did it, there was no remedy. We had no opportunity to fix it. I'm obviously out the door. This is my last committee meeting as a legislator. But that is the problem. The process is there. This legislative branch, we are part of the legislative branch and we have the ability to have hearings. The executive branch, which is also the Attorney General, should have been called before this body and they should have answered the questions, but they never showed up. And we were told, yeah, we can write letters. I don't want to write a letter. I want to look them in the eye and I want them to look me in the eye and answer the question. The bottom line is what they did was wrong. And it's been whitewashed. There's nothing we can do today. And unfortunately, the Lehmans that have been impacted, there is probably no remedy for them. But I'm trying to make a big enough deal out of this, that this body wakes up and that they address it. And I know the chairman has assured me that this is going to be resolved because it needs to be. We can't continue to have the executive branch feeling like they don't need to listen to what this legislative branch is saying. And yeah, we're only one part of the legislature, but we have a club. And we keep trying to use that club and it keeps being reduced to a stick. And we're even left to where we don't even have a stick now. We got a piece of rolled up newspaper and the dog's not listening. And I just hope that this body does take, and it is about process. The Lehmans got caught up in this, but this is about following the process. And how do we hold an agency accountable if they decide that they're just not going to do it? And then I'm going to say it again, because I want this body to remember. I won't be here to keep reminding you, but the problem comes from this body doing too much through rules and regulations. And that's the easy way. That's an easy out for us, because we can just say, we had no role to play in that because that was done through the rules and regulation process. Well, that process only exists because this body is too lazy to do their job. And so we need to be mindful anytime we see in legislation that it's going to be done through rules and regulations. As legislators, we need to be asking why. Why does it have to go through rules and regs, and why does it not go through this body? And yeah, all the rules and regs always come back to this body for review. But the problem is the rules and regs are already in place and we're going a million miles an hour, and you'll find that out when you get here. We don't have a lot of time to dive into all these rules and regulations, and we don't find them. We don't find a problem till it arrives at our doorstep, like happened to the Lehmans. And unfortunately, we see a business, some citizens in this state that I do think very clearly got the short end of the stick. And the government just ran right over them, and there's not even an apology. It's just like, yep. And all I can say is I am sorry, but the process, Bob, to your question, we can call for hearings. You see it all the time. They do it in DC. We have the same amount of authority as the legislative branch to call for hearings, and this body needs to start doing that more often. Thank you.
Go ahead.
Right, to be clear, as far as past, I mean, the Senate does have the ability or the requirement to confirm government appointees. That has generally been something we frankly haven't done much with. And I think there's been continuing discussion about having that be a more robust system, maybe like Mr. Worf is referring to, what you've seen on TV, where you have that formal hearing in front of the committee that has the jurisdiction over that particular agency. In the case of the AG, it would be the Judiciary Committee. And so that, in terms of remedies, that is one that the Senate has, not the House. Granted, I give you that, Mr. Worf, but that's one remedy the Senate has at least.
Yeah. Representative Fortner. Oh, Heather, go ahead. I'm sorry, I not seeing that far away.
There we go. Mr. Chairman, I just wanted to tell the committee that -1601 is advice and consent of the Senate.
Mr. Chairman. Just a last question, is that something that the committee could decide today to vote on, to call the AG for questioning at a hearing, or how's that process work?
Sorry, you're not referring to the Senate process of confirmation. You're talking about an actual hearing that would bring them here. I'm not sure.
Correct.
Let's go to our attorneys. Do they have an idea?
Oh, Mr. Chairman, not specifically to that, however, that typically a conflict of interest in a court case situation would be addressed in court. As far as the different bodies would then be able to present the evidence of whether there is a conflict of interest of one of the parties in the court. And for example, with this situation where there is the appeal to a district court that is provided for, and that's a de novo appeal. De novo means starting from the beginning and considering all of the evidence. Then what happens, and then just like any court case, then a party would put forth what their arguments are well, not a party, all the parties then would put forth their arguments for whether they're in a specific case would be some sort of a conflict of interest.
Okay. Does that answer your question? Okay. Yeah. Representative Fortner.
Thank you, Mr. Chairman. Is the Attorney General, since he's appointed, does that make him a judicial officer?
Yeah. Your staff get that question. Okay,
You're having a
go ahead and
microphone
ask
issue.
it again.
Would you be willing to repeat that question? I'm so sorry, we had a microphone issue.
Still hashing through the last one.
Since
Thank
the
you.
Attorney General is appointed, does that make him a judicial officer?
Mr. Chairman, the Attorney General is in the executive branch, and it is considered a state officer. And it is appointed, and that 9-1-601 specifically says that the Attorney General is appointed by the governor with the advice and consent of the Senate. And then there's the process for how the Senate does the advice and consent. So they're in the executive branch.
All right. Representative Wharf.
Thank you, Mr. Chairman, and I don't want to belabor this, but there is some confusion. We have the ability as a legislative body to have a hearing, and it isn't a hearing to relitigate, because that's what's being construed. And I'm going to make it very clear. The intent was never to relitigate the decision that was made. It was to find out how that process got derailed. We've had a witness that has brought information to us. We've had all the information that's been brought before us. The one thing that hasn't happened is the executive branch that was behind the decision that was made that overrode the recommendation has never answered to this body. And that's the purpose of the hearing. The hearing would not be to resolve what was litigated by the Lehmans. It is to find out why the process failed, how we got in a situation where a temporary use permit, how all the things that were just reiterated, how that stuff was never ever put in the file, how that stuff was never made available to the state land board, why they were led to make a decision without having all that information. That's what's at question. And this body still, you can still do this. If this body wants to call them before it, you can still have a hearing. I'm not going to be here. I'm not going to make that recommendation. I'm not even going to make that request because I'm not going to be here. And I don't think it's fair to obligate the next guys to continue down a course I wanted to go. But I can tell you, there's a problem with the executive branch not listening and not following what the legislative branch has given them. And part of it is due to the rules and regulation process. It's so vague that's allowed an agency to totally make up rules as they go. We were told they have unwritten rules. Well, how can you run an administration via unwritten rules and expect the public to live by that? And that's us. That's on us. We're the ones that have allowed the situation to be such that we have an agency that's using unwritten rules to make decisions that have impacts on the citizens of this state. And so I'm not going to beat this dog anymore, but I do think it's important for this body to understand. I never intended to have a hearing to relitigate. That was never the intent nor the purpose. The whole idea was the only way that this body can have the executive body come before it is for us to have a hearing and have them come. And yeah, there is a confirmation process that deals with the Attorney General, but that deals only with the Attorney General. It doesn't deal with the agency and how the agency interprets rules and regulations and all that. And so there is a problem. And until we can figure out where that problem was, I think it comes to the vagueness of the rules and regulation. That's my idea. But it's ultimately, since we don't know, we've not had that opportunity to have those questions answered, anybody's guess. So with that, I'm going to shut up. Thank you, Mr. Chairman.
All right. Thank you, committee. It would be, all right. Let's try to limit our time because we've got some bills. This is going to take a while to sort through some really important information that may remedy what's happened. So go ahead, Representative Fortner.
Thank you, Mr. Chairman. According to the Wyoming State Constitution, Article 3 and Section 18, the Attorney General can be impeached. And I suggest that we start that process since he's coming to visit with us. Thank you.
Representative Heiner.
Thank you, Mr. Chairman. We've spent several days through the course of the summer talking about this Lehman deal. Spent a lot of time in this body, this committee. We've heard one side of that issue. We've heard today that the Attorney General has attempted to squash testimony from the executive branch. I respect the branches of the government and but the checks and balances are real. So pursuant to statute 28-1-109, we have authority to issue a subpoena. It's issuance and service of subpoena. I would move that we subpoena the AG to come to a hearing, a one-day hearing with this body as currently made up, and request the management committee for the opportunity to reassemble for one day before this body disassembles, that we might be able to have the opportunity of questioning our AG about this. We have a background. We have information that we need to have answered. And before we break this committee up, and it's going to be reconvened with different members of the body in the future, but I would like to ask management council for permission to have one-day session and actually subpoena based on Wyoming statute. We have that authority to actually subpoena the AG to come and answer the questions that we still have unresolved.
So what I know about this, it's been done before where we've gone to management council and asked for time to review something that we didn't get right during committee, or we needed to reconsider. I guess I would ask the attorneys for clarity on that, or we'd be okay to do that if if this motion were to go forward.
Mr. Chairman, what different committees have done before is checked with their budget and consulted with management council as to whether there was sufficient budget and the consent for an additional meeting.
Okay. All right, motion's been moved and seconded.
Question.
Question's been called. All those in favor say aye. Opposed? No. Okay. Did voice vote on that's fine? I should have asked before we did it.
Mr. Chairman,
It passed
I,
by voice.
the presiding officer of each, a majority of the members of the body. There, it does not state in the legislation whether it needs to be a roll call. However, something of this nature, given that, I mean, then assuming that a meeting is able to happen, then it needs to be served. That's gonna, by a sheriff.
Mr. Chairman,
And
can I
then-
just call division? We'll have a voice.
For a
We
roll
could
call.
do that. Why don't we do that? And then
Yeah.
we'll be clear. We'll have. All right. Show of hands, or do you want a roll call on this?
Roll call.
Roll call. All right. We'll do a roll call on the motion. That's set before us. Go ahead, Clarissa, when you're ready.
Senator French,
Aye.
Senator Cole, Senator Cost, Senator Wasberger, Representative Blackburn, Representative Clausen, Representative Fortner,
Aye.
Representative Heiner,
Aye.
Representative Larson.
Aye.
Representative Western, Representative Worf,
Aye.
Representative Winter, Co-Chairman Boner,
Aye.
Chairman Eklund.
Aye.
Mr. Chairman, we have 10 ayes, 4 noes.
Thank you. The motion carries. All right, next item, we're going to talk. a
Mr.
little-
Chairman,
I'm sorry.
so how does the committee wish to proceed as far as this conditional upon the initial
Yes.
budget and management council consent to a meeting, and then this moves forward, or how do you wish to
I
do
believe
this,
the way
and what
we'll,
time frame?
I think that the way we'll do it is the chairman will come together before management council and make this request for the committee, if the committee's okay with that.
Mr. Chairman,
Somebody's,
a point of order.
oh, go ahead. What did I do
Um,
wrong?
Does this committee follow each house, the Senate and the House, or does it follow the total vote of the committee?
I believe it's a total vote of the committee.
Okay,
Am
thank
I
you, Mr.
correct?
Chairman.
I think I'm correct on that one. We never made a separation of the two houses. Okay,
Yeah, Mr. Chairman.
yeah, go ahead, Senator.
Yeah, so, yeah, I mean, what we just did, I'm not sure if I've ever seen that happen in my time in the legislature. And I'm just being perfectly blunt. I don't know what the path is forward, but we will go to management council and ask for an additional day. If they do not, give that to us, I imagine the next joint agricultural committee will receive the testimony, but that's me speculating. We have to figure a few things out as to how to move forward. And Representative Worth, the word is subpoena, not a hearing, and there's very specific ways to, just so you know. So, and well, and you need to, you know, and we just did that. So there, yeah, so, yeah, okay.
Yeah.
Okay.
So, and I have been involved in one of those, and it was more of a procedural deal in which during the meeting, we had confusion on a motion. And it looked like a fairly important bill hadn't been discussed. And we brought it back and we talked about it. Management Council approved that. I don't know what they'll do in this case because it's quite a bit different from what we tried to do then. We went back and tried to do committee work that we believe we failed to get done. This is is adding a bit of committee work and a whole different thing, and I know nothing about what the subpoena will involve. Go ahead, Heather.
Mr. Chairman, does the committee want to specify specifics? Typically subpoenas are going to request specific information. Does the committee want to dictate what what the specific information is?
I think it would be my suggestion that if we're going before management council, we better be pretty clear on what that's going to be. I'm not sure what would be more clear than the motion that we had. Was that clear enough or? Go ahead.
No, Mr. Chairman, those were not specific. For the attorney to come before this committee for a one-day hearing, that it does not specifically say what the committee, what it would be for, what the questions are, what the committee would want to know.
All right. Do we need an amendment or an addition to the motion, or just clarity in what we're going to ask management council for? We can. Go ahead, Heather. Help me out a little bit on what more we might need before we start the discussion.
Mr. Chairman, what I am saying is that the committee just voted to issue a subpoena to the Attorney General to come to a one-day meeting, provided that the committee requests a one-day meeting and has the budget from Management Council. And so what I'm saying is that the subpoena itself, when issued, because the subpoena is an actual document and it needs to be then served. And so the specificity that would need to say, typically a subpoena might be to produce specific documents and then it lists what those are, or to answer certain questions and it lists what those are, so that the subpoena has some specificity to the person it's being issued to.
Okay, thank you. Committee, or you have an understanding of what we'd have to discuss here to make sure we're clear on what we take to management council as well. And the decision on a subpoena has to be done now, because this will be in theory, is the last meeting we have. So let's go ahead and get that discussed. Senator Cost, go ahead.
Thank you, Mr. Chair. My question is, we have a subpoena, we have a hearing, or whatever you want to call it, but then that's our last meeting. What's the end result of what we're trying to accomplish? Because there's not another meeting or anything that we're going to hold in between then and whenever. So how are we accomplishing something out of this is what I would like to know.
Okay, I think I can answer that. The hope is that if we iron this out, we'll figure out what we need, the specifics of the subpoena. That probably it all dies if we're not granted an additional day to come back together and meet and with the Attorney General there to discuss what happened exactly. Does that help? Go ahead, Senator. I must not answer it very well.
Well, if I understand a hearing correctly, you can only have one topic that's dealt with in the hearing. I don't know whether we can make any decisions from that day or not. My question is, what's the end result of that? If we just have a hearing to have a hearing and we hear whatever we hear and we can't do anything with it, I don't understand the advantage of what we're doing. On the other hand, if we're going to have a meeting afterwards to do something with it, then I follow you. But my question is, are we going to be able to follow forward?
Okay, Representative Blackburn.
Thank you, Mr. Chairman. I think the senator might have some good thoughts there, but I think that we'll at least get the ball rolling so that the next Senate and House can grab the football and run with it. I really think we need to have a start, and we tried to do that in Cheyenne when we called for a hearing and that didn't work. So this might be a last resort to start something. And I'm not necessarily saying start a fight because I don't want to fight over this. I just,
Senator Kolb.
Thank you, Mr. Chairman. Yeah, I got, I guess, no opportunity to explain why I voted the way I voted. And I'll explain it in this way. I am not looking for a fight with the executive branch. I think there are things we can do as legislators to craft regulations, rules, sideboards to this issue. And that is our lane. I don't know why we're venturing off and scolding somebody. And I'm unhappy as anyone else is here about what happened. It was wrong. It was not professional. It was not done in a manner which I'd hope every citizen in this state can enjoy. I think that's what I know of the situation currently. But the solution lies within us, not within tampering into the executive branch's folks that they so decide to appoint. And there is an elective process for the governor, I might add, that appoints those people into those positions. There's a process. It isn't willy-nilly and it isn't done by the legislators. Thank you for my chance to comment on my vote.
Okay. Yeah. Representative Heiner.
Mr. Chairman, with respect to the question by LSO, I think we need to be, as LSO has mentioned, more specific about the reason for the subpoena. And so we would specify that it was to hear in regards to the Lehman matter, further testimony from our executive branch. But I would beg to ask the chairman if we could submit specific questions at the end of this day so it's that we can have time to discuss this as peers and come up with some specific questions we could add to that subpoena to satisfy the needs for granularity for tomorrow.
Yeah. Okay. Yeah, we're trying to decide on when we need to have this thing ironed out. So go ahead. You're good. Heather, go ahead.
Mr. Chairman, under the Wyoming statute 28-1-109A, about a committee issuing a subpoena upon the request of the majority of members of the body, if that subpoena if the specific content of that subpoena is going to change or be specific, as we've discussed, it would seem that it would need to be a majority of the members of the body. So the council, you or Chairman Boner, I did not catch you, said it, just gave about it being during this meeting. It seems as though I hear the idea, the concern of wanting to discuss it. However, if this body the majority of this body needs to issue it, then that would seem to need to be voted on while we're here.
So the first vote we had was not on the subpoena. I mean,
Mr. Chairman, this committee voted to have a subpoena. I'm saying if the subpoena changes from some vague, hey, you're subpoenaed to come here, which it ought not be a vague discussion or a vague subpoena like that, the specificity. So if the committee says, we want to ask question 1, 2, 3, and 4, that is the subpoena that the committee would need to be voting on. And as opposed to it being kind of concluded not at some sort of deliberative body here in the public like this.
Mr. Chairman.
Yeah, Representative Blackburn.
Mr. Chairman, Heather, I think we set the groundwork for the subpoena, and all we're going to do by tomorrow is add clarity to that subpoena, is what I'm feeling.
Mr. Chairman, yes, Mr. Chairman, sorry, and Representative Blackburn. Yes, and I'm just saying that the content of the subpoena ought not change after this meeting, but it sounds like you're planning on having it addressed at this meeting. And so I think I think that it could be that Representative Blackburn and I are saying the same thing.
So, and it shouldn't, Mr. Chairman. Mr. Chairman, Heather, I think that we don't have to vote on that then, do we? Shouldn't have to vote on that.
I think we do. And
on what, on the content of the subpoena?
Yeah, go ahead.
Okay. Mr. Chairman, I think I need to speak up and say, I don't know how this process works. I was not prepared to have this exact discussion today. So I need to learn more about subpoenas and what's necessary. The way I envisioned it when I voted yes is simply saying you need to come to this committee and we'll ask you some questions, just like normal. That's what I had in my mind when I voted yes. And so if we need additional clarification as to, what to bring ahead of time, as far as materials, that's something that I think we can maybe address hopefully tomorrow if there's additional clarity. But the way I understood is simply to require the AG's presence in front of this committee, and we could prepare the questions, between now and then. So if I'm wrong in that assumption, now's the time to let me know you're that, or we could maybe, allow our staff an opportunity to do a little bit of research and get back to us with some of these questions, preferably by tomorrow.
Okay, then I'd appreciate that too, because my vote was based on the idea that we've spent a huge amount of time on this already. In my mind, we've held hearings, and a part of that hearing that we haven't got has been brought forward enough, strongly enough that I think we could try to finish this thing. I really like to finish things. So we will prepare yourself to bring specifics. We'll discuss it probably tomorrow afternoon would be best. That would give us enough time. Will that give the staff enough time to answer some questions?
Yes, Mr. Chairman, we can look into this. An additional clarification that it seems like would be helpful in a subpoena. There's been a couple different veins of discussion this morning, and one is talking about the Office of State Lands and Investments procedures as far as communicating that information from well, there's been several things from the director to the hearing officer to the BLC, and there's that kind of vein of things. And then there's also the specific Lehman matter that the committee had all of the entire case file of that information. What I don't know, and I'm not trying to open a can of worms here, and I specifically am not trying to have a re-adjudication of a matter that is closed and settled. However, the committee has never heard from the other party in this case. And I think that a subpoena would want to specify that it's not being a re-adjudication of the matter, because that would be a glaring omission if that were the case, as far as not ever having heard any other sides to the story. So that's part of when I'm imagining crafting a subpoena, that's where the specificity coming in to say this is not a re-adjudication of the matter. And it is based on some of the information that the committee had, which is the entire case file. Or is it more focused on procedures and rules and regulations of OSLI? And see, those are several. That's why it's very broad at the moment as far as appear before this committee to answer a bunch of questions. There's no preparation. And that's where I'm just wanting to maybe direct the committee a little bit, or not direct, sorry, provide some information that the committee may want to consider as it is considering what specificity it wants to have for the subpoena.
Committee understands this? All right, go ahead.
Yeah,
Representative Ward.
Mr. Chairman, thank you. And I don't want to belabor this, but I think since this is all being recorded and our legal counsel just made a statement that I think it's important that this body also get on the record that the Lehman family has been to every hearing that we've had. And what's been absent has been the Attorney General or anybody else from the executive branch, with the exception of State Land Board. And it's not fair. They've already told us they can't answer the questions that we have. So the people that have to answer the questions have never appeared before this body. And I think that can't be lost. If we're going to have this discussion, they've had every opportunity to be here and they have failed at every turn. And that's why this body, and I think that needs to be taken to the management council. This would have been resolved had they showed up. They have not shown up. And we find out today that there was a message that was sent out telling the 5 state elected officials to stay away. And that, to me, if that doesn't concern everybody, those that voted no, that's why you guys should reconsider your vote. Those people need to be accountable, and I'm not going to say any more. I'm tired. Thank you, Mr. Chairman.
So am I. So we'll do some preparation. The whole committee will. Before adjournment tomorrow, we'll bring this back before us, figure out the specificity of it and figure out if we want to take it before management council. But all of it needs to be decided at this meeting because it's technically our last chance to do it. Okay, we're going to move on, please. Office of State Lands, come on up again. Director, when you're ready, just go ahead and proceed.
Thank you, Mr. Chairman. So the next item, I think you were wanting to hear from us on our state lands personnel needs. And since the last time we appeared in front of the committee, we've been navigating the supplemental budget process solely to address staffing issues at OSLI. Deputy Crowder and I have presented our plan to the governor. We don't know what his final recommendations will be. I don't think his supplemental budget request is out yet until the 21st, I think is the day. And then we've been asked to come to joint appropriations on December 12th to present the package to them. And essentially, as we discussed last time, OSLI is seeking 6 new positions. And while this seems like a large request, we think it really is the minimum number of employees we need to address the ever increasing workload and demands within the agency. And I would also note, committee, that to us, this is just the beginning. As we implement these new positions, we believe that there will be additional positions that will be required, particularly in light of some of the bills that the committee is discussing, such as the automatic renewal and the cure period. Depending on how some of that shakes out, we'll need additional staffing moving forward, we believe. So just to let you know, this isn't a one and done, at least as far as we're concerned. So as I mentioned, the intent is to spread out the large and ever demanding workload related to trust land management. Currently, as I've mentioned before, we have 1-person program managers, which is not helpful, particularly with large programs such as grazing and agricultural leasing. So for example, in that program with the 1 program manager, that position handles everything from all the correspondence with the applicants to the lease renewal process to the letters that have to be written, all of that. And so that's a huge job in addition to answering phone calls throughout the day and all of that. And we realized that with just 1 person in place there, maybe we need to create some redundancies and efficiencies to make sure that things do not fall through the cracks moving forward, particularly as the workload continues to grow. The other thing we need is more on the GIS side. We need to ensure that our data is accurate and reliable and that it's pushed out in real time to the public. A lot of people visit our websites and need on-the-spot information about existing uses of state parcels, and we want to make sure that we're providing that. And again, we need to add personnel to free up time for some of the positions we see coming down the pike. In addition to these 6 positions, and I'll go into the 6 positions individually here in a second, we're also going to be working with HRD to reclassify 4 existing positions in the trust land management division and hopefully merge 2 positions into 1. We think that that'll be a better and more efficient plan. We believe that in order for our needs to be met, that this plan only hangs together if we at least start with these 6 positions and the 4 reclassifications. We've noticed that with the high demands of the jobs that we have within OSLI, we've seen a significant amount of turnover. People are getting burned out. They're working very hard, and there's no help. There's no end in sight. We have people working across their areas, if you will, trying to help out when times get really intense. So the bottom line is we need help to address the agency staffing needs in order to do a good job and to provide the public with the services that they're entitled to. So with the plan, one of the first position I'll discuss is what we call a policy and planning sort of legislative liaison position. And that position will provide information to the public regarding OSLI's programs, both the Trust Land Management Division, the Field Services Division will also serve as a liaison with the legislature. And, we've had difficulty in the past trying to be timely and are responsive to this committee and to others, trying to get information needs met. And so this will help us with that, having one person that is responsible for that. The liaison position would communicate with legislature to make sure that their needs are timely met. The position also would be policy in nature, from the standpoint of we need someone to stay abreast of new and sophisticated land uses and policy issues, those things such as NEPA, carbon sequestration, hydrogen hubs, sort of the new and what's happening now uses of state lands. Jason and I currently are struggling to stay on top of all that. We are actually running the Sage Grouse Mitigation Bank program, and Jason's been instrumental in trying to get a carbon sequestration lease up and running, and it just takes time. And so we don't want to miss anything. We want to be fully informed of those new things coming down the pike, like hydrogen hubs and other things. And so this position would also aid with that. Then we are seeking 3 lands management specialists. And what we're thinking of is creating 2 teams dedicated, one to grazing and agricultural leasing, the other to commercial leasing. So those would each have heads, if you will. That two of the 3 positions would be added to the grazing and agricultural program. These folks would aid with lease renewals, competitive bid situations, subleasing, and assignments. Again, these are sort of high demand areas that need sort of additional, what I would term worker bees, folks that are in the trenches, rolling up their sleeves, doing the work. Then the additional position would be added to the commercial leasing program. This person would assist with application processing so that others can focus on use markets, rental rates, and up and coming new uses such as recreation, conservation, again, carbon sequestration, hydrogen hubs, that sort of thing, actual sort of implementing and pursuing those opportunities. Then we are seeking 2 field services positions. One would be geospatial, and that person would allow OSLI to be more responsive with real-time information related to state lands use, would assist with adding leases, easements, and other transaction information to the database. And then we would also need a data management person that would ensure the integration of the OSLI databases and provide for accurate, efficient, and consistent use experience. So this is kind of our high level plan. We believe that this is sort of the minimum, as I noted, to kind of keep the day-to-day functioning as the demands become greater and greater on the agency. But we do believe that OSLI is a bit at a crossroads. And what I mean by that is the view for the agency to just continue to handle the day-to-day sort of the issuance of the leases and the easements and that sort of thing? Or are we going to be more proactive in our revenue generation opportunities? And we have had discussions with the revenue committee about doing just that and being more proactive in seeking out revenue. As you have likely heard, revenue is down. It's upon us to utilize the state trust land assets for K through 12 education. And so as I mentioned, that's the crossroads, sort of status quo, or to move into these new and different role from the standpoint of the ability to be a little more proactive in seeking the revenue. So anyway, as I mentioned, we have not seen the governor's recommendation on the budget yet. We'll be in front of joint appropriations on December 12th. And so that's kind of the high level of where we're at. Deputy, what have I left out? Thank you.
Got a question. So on the 2 field positions, the last two that you talked of. What was the first one? The second one's a data management specialist.
The first one is a geospatial or a GIS person that'll help
Okay.
continue to build our databases. Right now, we have one person in that role. And of course, as you can imagine, just the daily changes alone, trying to keep up with is overwhelming. And so we're behind in that. So this person would aid in that.
Okay, thank you. Committee questions. Go ahead, Representative Heiner.
Thank you, Mr. Chairman. Director, I assume these additional 6 positions are in addition to those vacancies that are already approved that are vacant right now. So how many vacancies do you have? And the second question, if all the sideboards were removed, what percentage would you have to grow your department to handle the increased workload that you have over the next 5 years? What growth in your department would you, if there were no restrictions, what would you shoot for?
Mr. Chairman, Representative Heiner, Deputy Director, how many vacancies do we have? I know we just looked at that, but my mind is blank. So if you could help me out, that would be great.
Sure. Mr. Chairman, Representative Heiner, currently within the Trust Land Management Division and the Field Services Division where these are concentrated, there's 4 open positions, which is roughly a 30% vacancy in that area. And when I say open, we do have an assistant director coming on board at the end of the month. So we're very excited about that, but currently it's vacant.
So right now you have 4 openings, 1 to be filled, and these are all covered in the present budget, the biennial budget. Okay, those are. Go ahead, Representative Heiner.
How many do you anticipate asking, how many positions do you anticipate asking for in the next 5 years if you had your opportunity to grow your department to the point where you feel like you were adequately staffed?
Mr. Chairman, Representative Heiner, one little clarification I want to make from what the deputy said about the current vacancies. A couple of those we have purposefully not filled, hoping that we will get the positions and then be able to reclassify some of them. It doesn't make sense to hire at a lower level if the expectation is going to be up here. So some of those are vacant intentionally until we find out exactly what we're going to be successful in getting. With respect to future, that's a really great question. I don't know that we know that at this point, and largely it's because, again, the vision for the agency, or at least my vision for the agency, is to be able to go out and do the proactive revenue generation opportunities, to really look for those things that are even low hanging fruit at this point, but that's going to take bodies. And I don't know at this point, if we don't get these 6, if you will, to maintain the day to day, we won't be able to do that. We'll just be focused on day to day. But I don't know, Jason, do you have a thought on that?
The only thing I would add, Mr. Chairman and Representative Heiner, is that it's obvious our agency has tried to operate in a very lean manner for quite some time. We've been very sensitive to the thought of growing government and the thought of generating revenue, just like the director mentioned. We're pulled in 2 directions. We're at that crossroads, as she also mentioned, that we do need to decide, do we grow? Do we handle the day-to-day operations better than we have? Fill in some of the gaps that have been created as the workload has gotten bigger and lessees have gotten more sophisticated and they're demanding more information on a more timely basis? Or do we just keep having those errors and those problems continue? And that's not a place where we want to be. So we do want to grow. We do want to meet the demands of today, which is everything I just talked about, and be prepared to meet the demands of tomorrow. As the director mentioned, revenue is a very key component in our office. It's the key component in our office. And we have all been subject to the ebbs and flows of how our revenue flows into the state, and particularly to our beneficiaries. One of the goals of the director when she came in was to normalize that, to make that more of a flatter curve. And to do that, you have to be responsive, you have to be nimble, and you can't be responsive or nimble without more people. So we're addressing the needs of today with this ask, and knowing that there's another ask coming, because the needs of the future are big and very important as well.
And Mr. Chairman, I would just add that if in fact we are authorized to enter into agreements such as the recreation bill that the committee will be taking up later, that will inform sort of the number of people we're going to need into the future to, figure out what that looks like, how to handle that, how to handle those needs. And again, just the other revenue generation opportunities that we're looking to do. So I know that that's a non-answer to you with respect to the next 5 years, but I guess it depends. It really does. I think this would handle at least the immediate need. And then we would want to go back and look and make sure that the workflow issues have been addressed, that people are able to get the information out of the GIS component as we are anticipating. But if that's not the case, then of course we'll need additional folks for that. So there's just a lot going on. It's hard to anticipate a number at this point.
Representative Western.
Thank you, Mr. Chairman, Director Scoggins. Appreciate you coming here. You mentioned other revenue options. I know that's a long list of options that you guys do have at your discretion, but maybe for the record, could you talk about some of the ones that maybe jump out to you the most or seem the most appealing to you in your position as director?
That's a tough one, Mr. Chairman, Representative Western. That's kind of asking which is your favorite child. So, but yes, we are. I will say this, though. I mean, we have been exploring revenue generating opportunities in Teton County, particularly at the direction of the legislature, which, is fine. And we've done that through the Teton Village parcel, where we've looked at everything from glamping to landscaping to storage. We're also looking at opportunities in Teton County related to conservation. Is there the ability to work with the local folks up there and find a conservation lease for a number of years where we could, receive money for doing that? So that's one example, but there are also other examples. Particularly, we're looking at location of state parcels along some of the major thoroughfares like I-25, I-80, even some of the major highways, to see, are there more commercial type opportunities where folks can lease state lands for even long-term periods of time in order to effectuate things such as gas stations, commercial truck stops, housing developments. So there's a lot of things going on. And as we move forward, we'll be speaking with the legislature and legislative committee members about potential changes to the statutes that can also help us with that, because some of the things that we want to do may not exactly be authorized yet.
Representative Blackburn.
Thank you, Mr. Chairman. Yes, ma'am. Maybe I missed it, but when did we fund those 4 vacancies that you now have?
Probably was approved in the last biennium, wasn't it?
Mr. Chairman, yes, they would have been approved in the last biennium.
It was the last biennium.
Yeah, this year. Committee, any other questions? And so something I might add, on a lean budget. I've been here for 12 years, and different times we've gone into budget sessions without enough money. I guess I'm not talking close enough. And each time we do that, we make requests of every agency and everybody we know, from down to little offices of auditors and whoever, to make cuts. And most of those cuts end up in personnel cuts. So the legislature has leaned this down. It hasn't. The office has had to make those cuts, those decisions a lot of times, but we've certainly encouraged that. And now we probably need to reverse part of that cutting philosophy, because we've cut our revenue as well. This is an office that has the potential to increase revenue for the state of Wyoming. We need to look at how we can not just efficiently run it, but beneficially run it, so that we can generate some funds. So any other questions? All right. Thank you.
Thank you, Mr. Chairman. Thank you, committee.
Good. I don't see a break on this thing. So anybody who needs a break, you'll just have to kind of get out there and do it when.
Mr. Chairman, that was not intentional
I
to not put a break. It was to leave it at your will for when to insert breaks.
Okay.
I'll make a
Well,
motion. We
I
take a break,
think-
Mr. Chairman.
Oh, we do have somebody wants a break. So to appease Representative Blackburn, we're going to take a 10-15 minute break and hopefully not too long because I'd like to cover some of the bill drafts before lunch. Thank you. So committee, as we're settling back into our seats, the way we're going to proceed now is we're going to look at two bills kind of in parallel with two attorneys explaining them. Both of the bills, we hope, are kind of doing the same thing. We need to decide which direction we're going with them, and we'll have questions to ask. So Heather and Lucas, come on up. So pull out your, let's see, 23 LSO 10134 working draft 0.8, and then the cure bill, which is 23 LSO 0201 working draft 0.5. And we're going to try to understand how these work and which one might be best for the purposes that we have. So I think Lucas and Heather, when you're ready to proceed, go ahead.
Mr. Chairman, we were just going to proceed in the order on the agenda. And because the committee had seen the automatic application resubmittal first, although it has changed form quite a bit, but they're both in the statute 36-5-104 primarily. And so Luke was going to start, and then I was going to address 201. So he'll address 134 and I'll address 201.
Okay, go ahead.
Chairman Eklund, thank you. Yes, Luke Plum for the Legislative Service Office. This is 23 LSO-0134. It has been changed since it was last seen by the committee in Riverton. And so I'll just try and briefly run through here. This bill does still create a somewhat automatic process for the resubmittal of applications for leases of land for grazing and agricultural purposes. After discussing this bill with the Office of State Lands and Investments, what it would do now is when filing a renewal application, the Office of State Lands would provide notice to any current lessee of state lands for grazing and agricultural purposes, not less than 90 days before the expiration of the existing lease. That'd be to every current lessee of state lands. If the current lessee is still considered by the director to be qualified to lease state lands, then that notice shall include an invoice for the rental payment necessary to continue the lease. And it would also include a summary of the current lessee's lease terms. If the current lessee certifies that they are still qualified to lease state lands, they agree to the lease terms provided by OSLI, and they provide payment for the first year's rental within 30 days of receipt of that notice, then the current lessee will be considered to automatically resubmit their application. So it does put some, there's some work on the part of the current lessee, but it is essentially just certifying and then making the payment to guarantee that you want to continue that lease. If the current lessee fails or refuses to certify that they are still qualified to lease, if they fail to agree to the lease terms or provide payment, then their application will not be automatically resubmitted. However, any current lessee who is not considered qualified to lease state lands, does not have their application resubmitted, or essentially otherwise does not qualify to lease state lands, may still file a new application with OSLI, within that standard that is already in the current statutory timeframe of 120 to 30 days before the expiration of the lease. So if you don't get it resubmitted, you still have the option to try and continue the lease by filing a full application. In the event of any conflicting application, this bill does break it up into two sections here. So now this is the newly created B on page 3 of the bill. And with the notice that's provided to all the current lessees 90 days beforehand, if there is a conflicting application, that would be noted to the current lessee. And we did kind of change that time frame to 90 days to match this conflicting bid or conflicting application piece of this, so that if it's you have to have your conflicting application within 120 to 90 days. So then for sure OSLI would know when they're providing notice to the current lessee that there is a conflicting application. So that was the portion of that. And so if a conflicting lease application is received, the current lessee still would have the opportunity to meet the conflicting bid as it's currently laid out in the other statutory sections. If you still have the necessary use, you can still meet the if the conflicting bid is higher, you can still meet that as the current lessee and maintain your preferred right. And OSLI shall amend the terms of the lease presented to the current lessee, as I previously discussed, for the automatic application resubmittal. So that is kind of that process. This act shall apply to all leases of state lands for agricultural grazing purposes that expire on or after July 1st, 2024. That was just to make it so that there's a clean applicability period. And the effective date is also set out to July 1st, 2024. And that's just to give the Office of State Lands and Investments lead time to get these processes implemented. But with that, that's I believe that covers the bill, and I would stand for any questions.
Committee questions on what do we call this? State lands automatic application resubmittal. Okay. Should we go ahead and discuss the other bill? And
Yes, Mr. Chairman.
and if you can make comparisons, and I couldn't find deficiencies. It seemed like either bill did what we kind of wanted them to do, but I don't know if I went through them critically enough, but if you want to, you may point out anything that you think may be different.
Okay, thank you, Mr. Chairman. Heather Jarvis, Legislative Service Office. I am looking at 23 LSO-0201, working draft 0.5. This is the state land lease deficiencies cure process that the committee requested at the last meeting. And the biggest, okay, I don't want to speak in superlatives. A big distinction between the two is that this bill draft, which we will go through, it has the Office of State Lands notifying a lessee if the lessee fails to file an application or files an incomplete or otherwise deficient application, or if there's some other reason why the Office of State Lands and Investment has concern that about a lease renewal. That is what the OSLI tells them in this bill draft versus the bill draft that you were just hearing. OSLI does a complete deal without really hearing from the lessee. Looks at lease terms and everything before even hearing from the lessee that the lessee is even still qualified. So I guess the process basically kind of begins with the lessee in the bill that we're about to look at, and then OSLI lets them know if there's any deficiencies that they need to cure, as opposed to in the bill you just heard, the initiation being with OSLI. So that's kind of a big a high level view of how they're different. And the way that this bill addresses it then, as I just said, is that if there is some sort of, if the lessee hasn't filed by a certain time or files an incomplete or otherwise deficient application or otherwise causes the Office of State Lands and Investment concern regarding possible lease renewal, then the Office of State Lands and Investment notifies about specific things. They notify what those specific things are so that a person who is applying can cure that. They know what's wrong and they can address it. And those items are listed starting on bottom of page 2 through 3 as far as the specific things. For example, on item 2 at line 19 on page 2, that they need to identify the failure to file an application or the deficiencies in the application filed or what their concerns are. And then you'll see at the top of page 3, they provide the current lessee not less than 30 days from receipt of the notice to cure those deficiencies. And then they also have an indication, just like it says in other statutes, that indicate that failure to file a lease renewal will resolve or may result in the lease lands becoming vacant. Now, like the bill you just saw, this separates the conflicting lease process out just because they were all jumbled together in one big paragraph at this statute. So we have the renewal part separated out, and then now the subsection B, which talks about conflicting applications. So that's similar between the two bills. And then one additional thing that this bill draft does if you, well, would, if the committee chooses to accept several amendments that came from discussions with the governor's office and the OSLI after this had already been sent to you. And those are on a separate page in your material. Oh, I'm sorry, these were on your desk. And they were under your, under
Yeah,
the
committee-
agenda.
Committee, look, there, I
It's-
think everybody has.
Yeah,
one.
so it says Office of State Lands and Investments Proposed Amendment to 23 LSO 201.5. And what those do, just they add some additional cross-referencing. So just so they specify that in subsection A, it specifies that this can be, that the notice in subsection A can be in addition to the notice in subsection B, to keep those two separate, the two processes between renewal and if there's a conflicting application. So that's what that what that proposed amendment does. And then the proposed amendment also pulls in another statute, which you'll see at the bottom of that 36-5-109. This is just the statute about when rentals are due throughout a lease. And the reason for this was to conform timeframes for lessee compliance, just so that lessees aren't thinking, oh, it's 60 days here and 40 days here and 90 days here and 45 days. So to try to, the idea was to try to keep it when things are due throughout their lease, and then when their renewals are due on the same schedule, to try to keep that. So that's what the amendment does. The amendment also says that this act shall apply to all leases of state lands from 2024. And then it gives the opportunity, or tells them that they shall promulgate rules. And then it has the effective date be the 2024 by the time they've promulgated the rules for that. So that what I've just done is go through the bill draft plus the proposed amendment that you see there. And now I stand for any questions. I sit for any questions.
Committee questions, yes. Senator Kolb.
Thank you, Mr. Chairman. Giving notice, what do you envision that will be the vehicle in doing that? Is it certified mail, email, and also the cost associated with going through this process of giving notice?
Mr. Chairman, Senator Kolb, this bill draft 201, it does specify that the notice shall be in writing. And then the amendment on the amendment page, or another appropriate form of communication as determined and documented by the director. So some documented form for the as far as the information, and then it's the requirement for certified mail does not come up. That comes up in the inserted when rentals aren't due to be paid. That does have the requirement for certified mail, just because you need to be paying the rentals to keep your lease up to date. But as far as some form of documented notice of what the deficiencies are, it needs to be in writing 60 days out, and then if they're not later than 40 days before the expiration, then they need to have applied before 60 days out, but then there's 20 days for the OSLI to figure out that needs to be done. And then at 40 days out, they would have the notice that requires these things, that identifies the failures, and that provides the lessee 30 days to cure it. One very important amendment that I believe is supposed to be here is, I believe that on line 3, page 6, or sorry, page 3, line 6, indicate that a failure to file a lease renewal application or to resolve the deficiencies or other concerns by the due date. I was supposed to insert on this, should say may instead of will, result in the lease lands become. I apologize. I'm getting tangled here. Just a moment. That might not be the may that I'm talking about. Oh, thank you for your indulgence for me to untie my tongue here. The May that I was talking about is in the bottom of the amendment. When a lease is going to possibly become canceled if rentals are not due, that became, they need to be they need to be notified by certified mail that the lease may be canceled if the rent and late fee aren't paid due. So your question as to how they're notified, no final answer or action is taken before there's a certified mail situation. When it's this cure process that involves some back and forth of, hey, this we think is wrong, you got to work on that. That is needs to be in written or documented in some way, whatever the most effective form of contacting the person is.
A question I've got on you lost me a little bit on where this May is at, and it's got the certified mail. Where's that at? Again, please.
Mr. Chairman, there are the two locations. One, I believe, is one that, as in our flurry of back and forth, that I believe that we missed on page 3, line 8. Rather, letting them know that any deficiencies, if they fail to be cured by the due date, may result in the leased lands becoming vacant. The other may is at the bottom of the amendment in the inserted 36-5-109. And that's regarding certified mail that this proposed amendment doesn't have line numbers, but it's 3 lines up from the bottom that a lessee would be authorized or notified by certified mail that if they don't pay their rental by the time due, that it may be canceled. Those were the 2 mays.
Okay, I had the wrong piece of paper in front of me, so thank you. Committee, yeah, Representative Fortner, go ahead.
Yeah, I have a question on your draft number 8 there on the second page. I guess it'd be the it goes down here to where it says, on starting at 8 all the way down to 12, it says, well, up to 7, it says the Office of the State Lands Investment shall provide notice to any current leasee of state lands for grazing and agricultural purposes not less than 90 days before expiration of the existing lease, if the current leasee is still considered. I don't believe 90 days or 120 days is even sufficient for that. Pasture is extremely hard to find to go with your stock. So if you wait for 120 days to notify them that they're not qualified anymore to lease that, that there's somebody else that's more qualified than they are. That's not a sufficient amount of time for them to find some place to go other than the sale ring, in my opinion. Thank you.
Okay, I'm not convinced that's what it says. Oh, you're on the other bill.
Yes.
Oh,
Chairman Eklund, I believe this is on 134.
okay.
Just to briefly say, I guess currently some of the other prior language is that as A would currently read, it's that all applications to lease grazing and agricultural lands that are outstanding leases would originally have to be filed 120 days prior to and not later than 30 days prior to the expiration of the existing lease. So it wasn't trying to make anything different. The 90 days was just to match with the conflicting lease process. And those were just some of the numbers that were existing in statute. So of course it's, yeah, whatever the committee would determine would be important there.
All right, so we could change the number of days and how the mechanics of that lease operate. Does that help you, Bill?
I think they should be notified at least maybe twice that distance before the hammer comes down that they're no longer qualified. They might be running along thinking they're still qualified for the lease and really they're not, So I think that date should happen out another 120 days to let them know, hey, you got to go somewhere else. Most people plan on their pastures and their breeding and all that a year in advance.
Okay. Hang on
Mr.
to
Chairman.
that thought and we'll work on possibly changing it. Go ahead.
Mr. Chairman, there's another important distinction, Representative Fortner, in that there's a specific to qualify for leasing land in in statutory language, it is very specific. You have to be age of majority, citizen of the United States, and another bill that you'll look at in a little bit have actual use for the land, maybe. But anyhow, that qualification is not something that OSLI make a determination they make. That's actually in this bill 134, I believe. I think Luke will correct me if I'm wrong, but that the Office of State Lands does not know if someone's still qualified. And that's why when they get this notice, the lessee is required to certify, yes, I'm still qualified. And nothing has changed with those very fundamental basic things. I'm no longer a citizen, or I'm no longer of the age of majority, and that wouldn't really go. But I mean, so the question of qualification is not OSLI saying, hey, we no longer consider you that. It's the lessee certifying that they are still qualified based on what those basic statutory criteria are.
Good. All right. Any other questions on either of the bills? You have anything further to add?
Mr. Chairman, just to briefly address that last point, I do think, that if the current lessee is still considered by the director to be qualified leased state lands, I think Heather did a great job explaining that. I think it kind of came up in conversation why that was included more so was if it became very clearly obvious that the director of the Office of State Lands heard that, you, for some reason, whatever it is, you're illegally subletting or something like that. But I think those would be very specific circumstances. And that's why that's just kind of left in there to provide that little bit of backstop for the Office of State Lands and Investments.
Okay. All right. Well, it's our hope that we can fix some of the process with one or the other bills. We can't use both of them. It would then we'd have more confliction in statute, I would guess. Go ahead. Am I correct on that?
I was nodding in agreement, Mr. Chairman.
Okay.
Yes, it would quite possibly cause greater confusion if you tried to pass both these bills. While they don't amend the exact same lines of the statute, they would have timeframes all over the place. And one, the impetus comes from state lands, and the other, it comes, from the lessee. And when they need to do things, it would be, there is possibility for great confusion if you were to pass both.
If we found that let's say the first one, the resubmittal process, automatic resubmittal didn't fully address what we're trying to solve here. The cure process that we're visiting about here was brought to us by attorneys that use what is that?
The Federal
Yes.
Administrative Procedure Act.
Administrative Procedure Act. These are things I don't know very much about, but since on a federal basis, they have it in the Procedures Act. Would it benefit the state to look into that possibility as a fail safe of some kind in the leasing or other things? It can be a whole host of things that can go out of whack, and people can be out of compliance, and there'd be some kind of a process for any state agency or any individual to come back into compliance, have a grace period to come into compliance. Could that be brought in another bill? We're not going to get it. We can't get it done. This committee couldn't get it done now. And it might be another committee that would want to do it, that understands the state's Administrative Procedures Act. We have that, correct? Okay. As a possibility, to have something to fall back on in case our state land laws, rules, regulations don't address all the problems that can come forward. Do you see that as possibility, a possible benefit to maybe look into that as well if we were not to pass the Cure Act. To put it in another section is kind of what I'm wondering about, Administrative Procedures Act. And it wouldn't be just grazing, it would be other. There's a lot of leases that the state's involved with that would be affected by that.
Mr. Chairman, there are, without having to kind of look through our specific Administrative Procedure Act and know there are several periods where an applicant or appellant or what different players who are using the Wyoming Administrative Procedure Act have timeframes in which they're supposed to do things. This and so adding something as you're describing, that might be something similar to this bill, that would definitely be an insert and might be a heavy lift because this bill draft, for example, very specifically has OSLI identify incomplete or incompletions or deficiencies in a lease application. So it could be, it wouldn't be the exact same thing as this bill because this bill is very specific to state land leasing for the agriculture leases. But what you're describing could possibly be done in a procedural aspect in order to apply to any state land lease. It's hard to draft on the fly, but it wouldn't look the same as this bill.
Yeah, and I presumed that it probably wouldn't. I'm just should have asked this question before the meeting. All right, committee, any other questions on the bill? All right, could we get State Lands next to come up and give us your take on both of these processes and how they'd work for the State Land Board or the State Land Office? And then we'll go to public comment, maybe get some ideas from the ag groups as what they believe might work best.
Mr. Chairman, thanks for the opportunity to comment on these two bills. Jason and I have sort of divided and conquered on them just so that we could make sure that we were giving good information and feedback to the committee. With respect to 0134, I think our preference is a cure process as opposed to an automatic renewal, just because then I think we are more confident in the information that we are able to get, that it's been updated and understand who's actually the lessee. But with that, I would yield the floor to Deputy Director Crowder to kind of take you through more of our specific comments on these two bills.
Go ahead, Deputy, when you're ready.
Thank you, Mr. Chairman. And I really wanted to thank your staff on LSO because we went back and forth on these bills quite a bit. They are, as she mentioned, nowhere near what you looked at last time. And we tried to bring them into something that does decrease confusion and increase simplicity when leases are renewed or annual payments are made. And I don't know if we're there yet, and we'll discuss all the concerns there, but it was a great conversation back and forth and really appreciate their time. And the staff at the governor's office as well helped us through this process. We totally believe that increasing simplicity, increasing efficiency is important when renewing these leases. These are very critical leases across the state. It's the most prolific use of our land, so we want to make sure we get it right and that we're working in a very good way with our lessees and our applicants. I provided the committee with a pile of handouts. And so I'll start addressing those handouts as I go through our list of concerns here. But the very first one, it's noted as has page 1 at the bottom, but it is our grazing and agricultural lease renewal application. The Board of Land Commissioners worked at length over the summer on trying to increase the clarity of our application and make it easier for applicants to respond to, so that we didn't have issues when we did receive an application that we had to address. But it was clear in what we were asking. The respondents had an easier time of responding to those, and they have brought down the size and scope of this application to something that is just core to the requirements of existing statute. So when an existing statute requires a lessee to be have a minimum qualification as age of majority, as Heather mentioned, that's a question that's in here, but really reduced it down so that it wasn't an onerous or a long-winded type of an application. But I provide this to you simply to show you that the board understood that premise of trying to make this an easier process for applicants. And this is the most recent application that they approved after consideration during two separate meetings and a lot of input by the Wyoming Stock Growers Association. The second thing I'd like to show you is what I have noted in your packet is page 3. It's a timeline that discusses our existing process for renewing a lease. It also discusses how the cure process bill would insert new timing into the process. And then the amendment that Heather went through is highlighted in blue and how that may enhance that ability. But for me to read it on paper, I get lost in the process, and we're trying to decrease confusion as much as possible. So having it in a visual form, I hope will help you understand what we're trying to do here, or at least see the impacts of one versus the other. So quickly, I'll run through this. And Mr. Chairman, this isn't addressing any particular bill. It is tied more to the cure process bill, but I think both bills are highlighted within this timeline. Currently, the whole process starts at 120 days prior to renewal. And that happens with a notification from our office before that 120 days to let the applicant, the renewing applicant, know that their lease is coming up for renewal. We do that through certified mail. And that is a new process that we've inserted over the last 2 years because we had some issue that we didn't have the correct addresses on file. And, or some people just say they simply didn't get it. But if we send it certified, they're forced to sign for it. We know the day they got it, who got it, and we can have that working relationship with our applicant from that point. That is an increased cost to our office. I don't know exactly what that is, but it is an important piece of information that we need to know. That also kicks off the conflicting lease application period. In current statute, somebody can conflict a lease at its anniversary date, but they have to submit an application 120 days prior and not later than 90 days prior to that expiration date. That gives a conflicting applicant 30 days to submit that conflicting application. Once we get, if we get a conflicting application, and again, this process doesn't happen too often, 10 to 20 times a year, maybe out of 400 grazing leases that are renewing. At the end of 90 days, we notice the existing lessee that a conflicting application has been received. Sometimes it's one application, sometimes it's many, but we send them a notice to say you have a conflicting application placed against your lease. You may have a preferential right to match that bid. We want you to exercise that if you have it. So we need you to submit your application in so that we know who you are, make sure you're still qualified for the minimum qualifications, and give us an indication that you want to exercise your right to meet that highest bid. And that's the point in time when we send that notice out. And I appreciate some deference here because this doesn't happen exactly on these days. We're subject to holidays. We're subject to weekends. We're subject to everybody submitting their application on the final due date. So you have no applications received at the beginning of the period and all of them received on the last day. And so trying to crunch through that amount of workload may take us 5 or 6 days past these deadlines to send that second notice out. So I want to make sure that everybody's aware of that we strive, but we may not meet this. Again, as I mentioned, we asked the existing lessee to exercise their preferential right 30 days after that notice. Again, that's another certified notice, and that's only in the case that they get a conflicting application. When we received the existing lessee's application back and desire to meet that higher bid, We then review both applications and the director issues her director's decision. At that point, we understand the lessee's qualifications, minimum qualifications. We also understand the ability for the existing lessee to exercise their preferential right. They meet all the requirements to be able to do that are laid out in statute, and the director makes her decision from there. She is required through a different set of statutes to provide that director's decision to all of the applicants involved in the process. And that happens roughly right here. They are allowed for 30 days to appeal that director's decision. And you can see that at the 30-day prior to expiration portion of the timeline. Our amendment, what we promoted to do is to, and again, to decrease confusion in all of this process, is to synchronize all of the due dates as much as possible on the same day. We've spoken before this committee before, and our grazing leases run for a 10-year term. 9 years out of that 10-year term, the lessees have the anniversary date of their lease in mind. That is when payments are due. You have that date to do it. Otherwise, you have 30 days to pay it, or we'll cancel and you have to pay a late fee. But that anniversary date's in their mind 9 out of the 10 years. 1 out of the 10 years, this earlier renewal date is in their mind. And the point of confusion that we hear regularly, or if they miss that deadline, is that we thought we had the anniversary date. So what we're trying to do with our amendment is to marry those deadlines all up to the exact same day. And I'll be honest, this will be an administrative nightmare per se for our office to manage the leases in different different due dates, I guess, because you're only going to be able to change this once the term of the lease is up. When a new term of lease comes, then it'll be subject to a new rental date. And we'll have to educate our applicants and our lessees of a couple different deadlines. We have many lessees who hold many different leases, and they could be all over the place. But our intent here is that at the end of the 10-year period of all the weirdness and education, that everything is exactly the same. And I don't know of a better way to do it. I don't know that we can go in and change the lease terms without a massive amount of effort to bring everybody to the same page right now. But this in 10 years, and it'll get increasingly better as we go through the 10 years, will bring everybody's mind to 40 days prior to the anniversary date of the lease. And you're either renewing or you're paying your rental. You're getting all the notices for everything on the same day every year. So all 10 years are exactly the same. Mr. Chairman, as I go through the timeline, the draft bill inserts everything in orange, which means that the existing lease renewal application submission deadline is moved from 30 days to 60 days before the anniversary date. We have 20 days to understand if a renewal has been submitted or if there are issues with that renewal application. And at 40 days, we will start providing those notices as the draft bill indicates, trying to get those individuals to apply or fix something in their application so that they're compliant with the minimum qualifications. And if they don't do that prior to 10 days before the submission deadline, then the lease simply is not renewed or expires on its own terms. Mr. Chairman, that's a lot, and I've got a few more concerns to run through, but I might stop there to see if there's any questions.
Committee questions? When I would have the administrative nightmare that you spoke of and how the office is going to know, because these aren't all going to happen at the same time. They'll happen kind of in a continuing process. Do you have an idea how you might resolve that administrative nightmare?
Yeah, and Mr. Chairman, everything we're talking about today, including the new personnel package, all has a role to play here. So increasing more individuals into this program divides the workload up among more people so that they can pay better attention to the renewals as they're coming in and what part of the process they're in. We also know we'll have to do a computer database upgrade, and a lot of the kick out of the notices all happens automatically when we hit a button or when we put certain triggers within that database. So we'll need that kind of an upgrade to make sure that happens. But I think that we can, with a little bit of effort, put everybody into the appropriate bucket that they would be in.
All right.
And Mr. Chairman, all of this is a confusing process. This is the most prescriptive process in statute that we have for leasing, and we've discussed that in the past. What we would like to do when we offer you these amendments is decrease the amount of confusion an applicant has to go through to renew their lease, meaning decrease the amount of steps they need to go through, decrease the amount of confusion about which process they're actually in, which is why we feel there is great merit in having an automatic renewal process. How it's written here causes us concern for a lot of the reasons that Heather mentioned and that I've already gone through. Timing is a big one, decreasing confusion there. But there's also just things within the bill that we have a little bit of confusion about ourselves. And that's the difference between lease terms and lessee attributes, if you will. The way the process works now, we accept an application in, we review the application for qualifications, we provide it to the Board of Land Commissioners for approval. They either approve renewal of that lease or not. And if they do, we submit the lease back to the applicant for signature, ultimately getting their agreement of the terms of the lease at that point. If they sign, send it back, then the director signs it as well. And we have a contract at that point. We have an agreement at that point. Our concern is if we start sending lease terms to the lessees prior to any of that occurring, they may feel like they have agreed to those lease terms and the board has not. The board has not approved them to be renewed. And so we want to make sure that we get the information from them. We get the lessee attributes from them, any changes to those attributes, meaning name, telephone number, addresses, anything else that can come in and we can try to make the process a more efficient way that way. But calling it lease terms causes us an issue with the lessee may feel they're in an agreement before we do. And that's a weird spot to be in. The bill also at the end of the bill talks about an opportunity for the lessee to meet the high bid. And we would like to clean that language up to make sure it matches the rest of the statutory language as far as exercising a possible preferential right to renew by meeting the high bid. Again, if we do receive a conflicting application, we want the ability to ask the current lessee for an application. The way the bill is drafted now, they wouldn't be submitting one. However, if the director is going to make a decision between two competing lessees, we need to know the information from two competing lessees. So we ask at that point to still be able to require an application from those individuals if they have a conflicting application put against the lease. Mr. Chairman, I can go into a little bit more detail on the cure part of the bill, but I think that wraps up the majority of our concerns, unless you have something for the automatic application submittal.
Okay, so just to summarize, the administrative nightmares with the automatic reapplication, is that correct? And you've provided amendments to the separate cure process that makes it easier to administer from your perspective. Is that just make sure, because I think we're kind of jumping back and forth between two bills and that confuses the committee, I'm afraid. So just make sure that's abundantly clear.
Yeah, Mr. Chairman, you're correct. Confuses me as well.
But it is necessary confusion in order to figure out what we're going to do going forward. Oh, yes, Representative Larson, go ahead.
Mr. Chairman, I guess I am confused also, but so leases come up every 10 years and they can come up anytime during the year, or are they all set like the end of March for that year? I guess is one of my questions.
Mr. Chairman, Representative Larson, that's a great question. I actually had written a note to respond to that. I apologize I didn't. But Representative Fortner brought up a good point in his comments. It's important to note that grazing leases are only renewed during one part of the year. We have leases that are divided up among areas of the state. We divided the areas of the state into three separate areas. So you have the southeast, the northeast, and the whole western half. The southeast leases renew on January 1st. The northeast leases renew on February 1st, and the western half renews on March 1st. So 120 days before then is fall going into winter. And I hope that has some help in people trying to make management decisions and things like that, because it's not the active part of the year.
Any other questions, committee, before we go on? Okay.
Mr. Chairman, I would like to start with the difference between, you had mentioned of the Federal Procedures, Administrative Procedures Act as far as a cure process. We have looked into that as well and don't feel it's 100% applicable to the conversation we're having today, meaning that it's in term type of a cure process. It's not at a renewal of a permit. It's not when there's a definitive deadline to respond by. It's if something during the term of the lease or the permit has happened, allow the applicant or the permittee to do something to cure that deficiency. We have the exact same thing in several places within our management realm. It's not explicitly written out in statute here, but we rarely, unless somebody doesn't pay a bill, pursue a cancellation of a lease because of poor management, poor neighbor relations, or overgrazing is a great example. We get complaints a lot that folks are overgrazing during the term of their lease. We approach those lessees. We talk about what's allowed in the lease as far as use, ways that they could do better range management to not overuse that property. And if we can't get there, then we try to put them in a grazing management plan, all prior to going to the Board of Land Commissioners and seeking cancellation of that. So what I want to be clear about is the federal process is inside the term of a permit, not at the end of the permit where we would have a deadline for renewal. That's what we're inserting in with this statute is what would happen at the end of the term of a renewal. How could you cure any deficiencies? And so I just wanted to make sure I made that point clear. One thing that we want to do with the timeline is to really maintain the integrity of the expiration date. If there's an issue with the lease and it can't be cured prior to the expiration date, in this process, we wouldn't go past the expiration date. Every time we go past the expiration date, and we have those one-off situations right now where that happens, we bleed into the next operating season. We bleed into the next farming and grazing season, which causes a weirdness on who can actually be on the property and what can they be doing. So we want to make sure that all of these issues are handled prior to that expiration of the lease, so that when they get into the operational phase, the roadmap is clear. Pardon me, Mr. Chairman, I'm going to go back through my notes real quick. So as the director mentioned, we feel this is part of the process that can be changed relatively quickly and without a lot of, there's going to be some administrative pain to go through, but this is one that we can operate in a much more simple manner while we're working on trying to get an automatic lease renewal process put in place. Heather went through all of the amendments, and again, I want to thank her for allowing us to work with her on that. The first amendment, part of the amendment that I would highlight is when we insert on page 13, page 2, line 13, we wanted to make sure that we were separating notices out. The one notice is very clear to the renewal of a lease, and the second notice, and that's on a second amendment. Further down, that there's two separate notices here. We're not trying to squish the time frame to a point where one notice can handle all, and that might be a situation that could occur, but specifically, we need one notice for renewal applications and one notice for non-payment going forward. The second would be the notice to be in writing. We asked for an amendment to include a more flexible scenario, meaning that we have situations right now where we do need to send a notice in writing. You haven't submitted your application. We need it back now, and we need to have that very formal back and forth communication with the applicant. There are other situations where they simply don't check a box. One of the most overlooked boxes is, are you eligible, or qualified to do business in the state? Are you a registered entity of some kind? And do you have actual and necessary use of the forage? Those can be handled either by an email or a simple phone call. And so what we'd like to do is be able to keep that flexibility in this process. So we're not sending a letter to an applicant who just simply missed a checkbox. In our current process and what we'd like to codify here is that we document that communication with that lessee. So if we ask them to, you missed a checkbox, can we check the box for you, or tell us what the appropriate box to check is? They tell us that and we can document it. We can save that for future use if we need to. Mr. Chairman, on the draft bill on page 3, line 21, we asked to insert the word complete in front of lease. We do have issues where some leases are missing the signature. Some leases are missing material facts that we need to make sure that they meet the minimum qualifications per statute. You have in other places of the statute a definition of complete of everything that needs to be included in an application. So we just ask that we further ensure that we get complete lease renewal applications when they come in. And then at the end of that sentence, one of the pieces of weirdness that we have is folks will send in the application because that's what the statute says, but then they forget to send in the annual rental that meets the highest bid or the difference between their minimum bid and the highest bid. And so we want to be clear here. We want your application, but we also need payment to move forward. And so we hope that the amendment does that. And then our request to pull in the annual rental payment as part of the amendment is, again, as I mentioned when we were talking about the timeline, to bring all of these dates to the same time so that 10 out of 10 years, we're talking about 40 days prior to the expiration and not 9 out of the 10. Mr. Chairman, I will stop there and answer any questions.
Committee questions? Okay. You're good?
Yeah, Mr. Chairman, I've got nothing more.
All right. Okay, well, thank you very much for your explanation of especially of this amendment. We'll call on the public to come on forward and probably Jim, you come on up first, would you?
Well, thank you, Mr. Chairman. Jim McGagnon with the Wyoming Stockgrowers Association. And if I might take just a moment as I sit here today, it's with a little bit of sadness, noting the passage this past week of the longtime Senate Chair of the Ag Committee, Senator Jerry Geist, and sat in front of this committee with him many times and had some very good experiences with him, which continue to have with certainly the current leadership as well. But I think that's worth noting. Having said that, I'll offer our comments on the two drafts that are in front of you. Looking first at 0134, the automatic application resubmittal. And while in principle that sounds great, it sounds like it really relieves the grazing agricultural lessee of some responsibilities. They still have those same responsibilities, and a little bit of concern does it give them a sense of confidence or relaxation. Gee, I don't have to do anything, when in fact that's not the case. But be that as it may, and as we move forward, our recommendation is going to be that you go with the second bill that you have in front of you. But just a couple of brief comments on that, the automatic renewal bill that come to my attention. One of those is that it provides for a notice not less than 90 days, and then that you have to submit your payment within 30 days of receipt of that notice. That leaves it wide open that the Office of State Lands or the Board of Land Commissioners could decide, instead of 90 days, let's make that 180 days, and the money's due in 30 days, so we'll get our money faster. So I think if that were to go forward, there needs to be not only not less than 90, but perhaps not more than 120 or something like that, because payment is so tied into that. And that's a concern in that way. The one other item specific to that bill on page 3, beginning on actually on line 3, any current leasee is not considered qualified, does not have the application resubmitted, has substantial changes, or may not otherwise qualify. That's quite a wide array of things. And if for example, it's because you have substantial changes in your lease, they're now requiring you to file a new application. My question would be, does that mean you have forfeited your preference to renew just because you were making some changes to your lease? And that would be a concern if this bill were to go forward. So those would be the two minor items that I would raise for concerns for further consideration should you decide to move forward with 134. Turning to 201, if I may, Mr. Chairman, and the amendments that have been offered to 201 as well. One thing I would note at the beginning, starting on page 2, it starts out by saying that the leases need to be filed 120 days prior to, not later than 60 days, et cetera. What I don't see in here is any language, as there happens to be in that other bill, addressing at what point the Office of State Lands would send you the initial notice that you need to renew your lease. That's something they've always done in the past, and I'm not sure if it's in legislation or if it's just in their rules, but certainly if you need to file not earlier than 120 days, not later than 60 days, there needs to be a notice to you that your lease will be expiring this year, and so would ask that would happen. And then the next item, the not less than 40 days before the expiration, if you fail to file an application, and I'm trying to track these timelines, then you get a second notice, and that we're certainly very supportive of that. That's what we have been asking for this committee to provide. And then once you get that second notice, you have 30 days to comply with that. The one no, I believe that part is fine, actually, as I look at it again. Don't think we have any concern with that. I would go down then to the proposed amendment to that draft that has been brought before you, and the amendments to 365104 I believe are appropriate, and we would be supportive of those. Do have serious concern with the addition of 365109, and this has to do strictly with annual rental payments, not with lease renewals. But currently on an annual rental payment, your payment is due and must be received by the expiration date of the annual expiration date. Under this new language, that payment is now due 40 days in advance of that. And 40 days in advance, certainly at least initially, is going to cause some problems for some of our people out there, because it's going to mean that they're going to have 2 annual payments falling in one calendar year, for example, or such a different time. And that is of some concern. Then of even more concern is the language that says if the rent is not paid by the due date, which is 40 days before, as I read this, then you'll be notified, certified mail, that your lease may be canceled if the rent and a late fee of 10% is not received within 30 days following that. So if I read this correctly, and I've tried to track it, you're having a 10% late fee imposed on you if you haven't paid 40 days prior to the due date. And that does not seem appropriate to us. If you haven't paid by the due date, certainly, and you had given a grace period, then a penalty would make sense. But to say that the due date is 40 days before, and if you haven't paid, then you have a penalty. So our recommendation there would be on, well, there aren't lines there, but in the paragraph that said if rent is not paid by the due date, to strike the due date and reinsert the anniversary date that was in there to begin with. So the penalty only applies if you haven't paid by the date that your lease would otherwise expire, not by not having paid 40 days in advance. And finally, Mr. Chairman, the last thing that I would raise, and I certainly understood and appreciate the challenge that the Office of State Lands has in implementing a new system like this. But given all of the problems we've had in the last couple of years with lease renewals and leases being declared vacant because renewals weren't received in a timely manner, and that it really concerns us that this part of the act wouldn't become effective until July 1st of 2024. And since lease renewals are in January, February, and March, typically that means it would be 2025 lease renewals before this would become effective if it were passed in the 23 session. And our request for your consideration would be that that you make the other sections of the act effective instead of July 1st, 2023, immediately upon passage, and then make the more substantive provisions effective on July 21st of 2023. And given the fact that legislation would likely be passed out in March, would become effective then, that would, and the initial notices for renewal would not be going out until September. That would still give the Office of State Lands several months to go through a rulemaking process. We believe adequate time to complete rulemaking before beginning just issuing the notices with regards to renewal for the 2024 renewal cycle. So would ask that you consider moving that up in those two ways. And with that, Mr. Chairman, would be happy to take any questions.
Okay, yes. Chairman Boner.
So just so I understand what the comments regarding to 36.5.109, would you be okay with that paragraph then if we just simply did the striking the on the due date and reinserting anniversary? Is everything else in that paragraph okay, or you want to get rid of the whole paragraph?
Excuse me, Mr. Chairman.
We're trying to figure out how to cure the cure here. And
Mr. Chairman, Senator Boner, we would certainly be much happier with it. It's still requiring people to pay 40 days sooner than they currently do, but I understand some of the reasoning to keep the consistency there. But as long as there was not a penalty, so long as it was received by the anniversary date, we would be comfortable with that.
Thank you, Mr. Chairman.
And I think we'll probably have State Lands come up and help us through that so that we know we're getting the amendment done the way you want it done and we want it done. Other questions for Mr. McGagna? So you'd be maybe looking at three amendments here. A change, page 2, about line 8. At what point do they send out notice that the lease is expiring?
Yes, Mr. Chairman, that would be the first one.
We'll find out from Office of State Lands if you could, maybe we already have this in statute, we're just not seeing it here. If not, then we need to probably include that. The second is a cure for the cure, which is the 10%, the possible 10% penalty 40 days before it was actually before it actually expired, and then the effective date. And the effective date, I think that makes sense sense to me as well to get this done as quickly as we can.
Thank you, Mr. Chairman. Those are the three changes at
All
this
right.
point that we would be recommending to that bill.
Okay. Committee, are you good? Thank you.
Thank you.
Jim. Further public comment? Mr. Moline, good afternoon. We've
Good afternoon,
we
Mr.
used
Chairman.
up the morning.
Is it still morning?
No.
Good afternoon. Standing between you and lunch, I'll
Well,
try to be,
you know,
I'll try to be brief.
so the committee knows we may break before we actually work the bills unless we're ready to work them and do lunch and come back afterwards. We'll
Mr.
figure
Chairman,
that
Brett Moline, Wyoming Farm Bureau Federation, looking over these bills. I believe the 201 is probably a better bill. Agree with Mr. McGagna's comments about, when it's actually paid. And then I believe also on page 3, line 8, I want to make sure in my mind that in the middle of line 8 where it says will, is that supposed to be a may? I think that's what I heard, but
yeah.
okay, I wanted to make sure I was clear on that. And then on the amendments, about the part on page 2, line 17, where right now it says writing, the proposed amendment or another appropriate form of communication as determined and documented by the director gives me some pause. I really don't know what that means. I mean, to me, email is still written. I believe that I think that's an accepted form of written. But it gives me some pause to open it up to any other type of communication. To me, it should be nailed down a little bit harder because, thinking of my family doesn't have a state land lease, but given our, I don't know how to say it, but at the family ranch, the operator of the ranch doesn't have email. He does not use the internet. Phone calls, given our uncertainties of the landline, the ability to get phone messages isn't the best. That's a function of where we live, but I know my family isn't the only people in that predicament. That gives me some pause. I really don't understand what it means to have you. It's easy to document, I called somebody and you have the documentation on one end, but you don't have it on the other, that they actually received the call. And I guess I hate to come to you without a solution to that. Perhaps there is a solution that I just don't know about. With that, it just gives me pause that it's kind of wide open with nothing really nailed down. With that, Mr. Chairman, I would sit for any questions the committee may have for me.
Yeah, go ahead, Chairman Boner.
So thank you, Mr. Chairman, Mr. Moline. It would be, would it help you if we struck or and insert in addition to? So they can call and say, hey, can we fill this out for you? That's what the testimony we heard, but still send it in writing. And, if just as a catch-all, I guess, to make sure it's good to go, would that alleviate the concern?
Mr. Chairman, Senator Boner, yes, it would. Thank you for that. That's a good solution. Wished I would have thought of it, but I didn't. So greater minds prevail.
You have it. You have it kind of marked down. So, all right. Okay.
Mr. Chairman, I'd sit for any other questions the committee may have for me.
Thank you, Mr.
Thank
Mullin.
you.
Others? Secretary Allred, come on up.
Thank you, Mr. Chairman. Not as secretary, just as Carl Allred.
Okay.
Make some comments here. I agree with both Mr. Moline and Mr. McGagnon on the anniversary date thing and the writing. That was another one that I had some concern with. One other thing that I would say is on the proposed amendments to it. down at the bottom where it says section 3. It says this Office of State Lands and Investments shall promulgate rules and create any forms necessary to implement this act. I'd prefer to see it say shall create any forms necessary to implement this act. I believe this is the rules right here, what you're passing. And to hand over that as Representative Worf spoke previously, that's your job, create law, pass the bills, not to hand it off to an agency. And I think that they've done a good job hitting all the marks in here. So I don't think they need to create rules. Last thing that is kind of concerned to me a little bit, and don't really know what the best answer is on this, but let's say that we have somebody who has an existing lease and that's their ranch and they have built their business on this. Now, lately, we've seen a lot of people come into this state that have a lot of money. And they have the potential to turn around and say, hey, I'm gonna, if that lease is running at $350, walk in and say, well, I'll give you 2,000. And run that rancher completely out just because they have the money, and that's happened. They have the money to do that, and that rancher cannot meet that. So I don't know if maybe I know we've got to manage the land for the best use for the state. But maybe if we put a cap on that and say, hey, if you have an increase of say 20% over, that you can keep your lease. Other than that, we're going to let somebody who has the money walk in and take it away from you. I don't know what the best answer is, but I do know that when we have some of these people coming in the state that have that kind of money. And I think that can hurt some of these ranchers who have these existing leases to renew them. Anyway, that's my thoughts.
Yeah, we'll probably have the state land office come up and maybe address that. I think we kind of do have caps. I'm not sure of that, but we'll ask them about that. Yeah, go ahead.
I think we need to review what this bill is for. It's meant to ensure that, we don't have leases go vacant. And so I think that as an ongoing concern, I think something we've been grappling with on this committee, but it's kind of outside the purview of the bill. This is meant to, we don't have the lease go vacant just because paperwork wasn't correct or somebody missed a deadline by a little bit. That's the purpose of both these pieces of legislation. So at which point, if it's vacant, all of a sudden it becomes a free for all. And anybody can come in with fewer limitations, less, consideration given to the current lessee. So that's where we're trying to get that problem. And that's the reason for the bill. I'm not sure if we state that explicitly. But yeah, I think that's a very complex topic that would probably require a constitutional amendment that is well outside the scope of this piece of legislation. So appreciate the input. Like I said, this is something we've been grappling with for a couple of years now. And we've had you can go back and watch our June meeting, and we're grappling with just that. In the context of one rancher versus another, one oil and gas company versus the current grazing lessee. And that's something we're going to have to continue to grapple with as we move forward. Because like I said, this process and the context in which this process is playing out is completely different than what it was in 1890. I can guarantee that. So I appreciate the input, Mr. Chairman. So.
Thank you. Okay. So when we're done, we're going to be hungry when we're done with this, but any other public comment? So committee, what's your pleasure?
Mr. Chairman,
Yes.
I'd move 23 LSO 201.
Okay, working draft 0.5.
Yes, Mr. Chairman.
Okay. Seconded by Cost. Okay. Yes.
I have an amendment. We'll start with the easy one first.
Okay.
On page 3, line 8, strike will, insert may.
All right. Been moved and seconded that we amend line 8 from will to may. Any discussion? All those in favor say aye.
Aye.
Okay. Next one.
Okay, and the next one, we're gonna need state lands back up here, dealing with page 2, line 4, talking about that initial notification at the 120-day point. Just a brief explanation what the status is currently. Is that something that you give notice for, or is it just kind of known that they're supposed to, they can't apply starting at that point?
Thank you, Mr. Chairman. Mr. Co-Chair, I was searching my memory if it's actually codified in rule or in statute, and I'm drawing a blank. But what we do as an existing process is at least 15 days prior to that 120-day mark. So many days prior to, but we send notice, a certified notice to each renewing applicant. And the notice includes a cover letter indicating any changes to statute or rule that have occurred in the past 10 years or so. Anything of note that they need to pay attention to, that being weed and pest or subleasing of some kind, and the change in annual rental that's expected to be paid. Also with that comes the application. So we give them a physical application to fill out in that notice so that they can return it back.
That helps, I think, alleviate that concern, Mr. Chairman. If we could have one more before you go. We had some discussion on page 2, line 17, talking about having be in writing or some other communication. What would be the impact if we said in addition to? So you're not limited to simply sending a letter. You still probably have to send it, but you could also just pick up the phone and, still send the letter as a, so we can be assured that it does reach them, but it wouldn't prevent you from saying, picking up the phone and say, can we check a box for you?
And Mr. Chairman, Mr. Co-Chair, I think that's a fine change. The impact is, as I read what you just said, was that we would do both. We would always be sending a letter. Even if we got a response via an email or phone call, we'd be following that up with a letter. So I don't know if that's the intent. Those letters would be non-useful, I guess, at that point. We would have them documented in our system. So up to you, I suppose, there, but that would be the impact.
Any more Willie's here?
Okay.
Just a second here. Hang on.
And Mr. Chairman, I might follow that up with, that's a 20-day period for us to do that notice. I think many of you are aware on this committee, we do a very high intense phone call blast to anybody who's not compliant with this right now. If they haven't submitted their application, that's what our staff is doing right now as we speak, making those phone calls. This bill shortens that period of time to 20 days. So for us to understand where the issue is, to generate a letter and to mail it out within that 20 days, it really gets to be tight.
Okay, so instead, what if we flipped it, say, the notice shall be in an appropriate form of communication as determined and documented by the director, or if that communication failed in writing. So we have the fail safe of the writing. If you can't get a hold of them, or something along those lines, would that be workable then?
Mr. Chair, Mr. Co-Chair, yes.
Okay.
And on the effective date. Oh, go ahead, Senator Cost.
Thank you, Mr. Chairman. I was going to say, or if you were doing email or something, would it be best to say, as long as there's confirmation on both ends rather than just one end, so that the office can't say that they emailed, but nobody knows whether they received it. We would need to have confirmation both ways that we've received it, so that if it's not that letter, at least we know we've got both ways covered.
Okay. Let's figure out how we're going to craft that into the bill. And Then there was the discussion of the effective date to try to get this the meat of the whole thing done as quickly as possible. You're pretty good with that?
Mr. Chairman, I'll relay my concerns with that. In order to initiate the regular rulemaking process, we need to go to the Board of Land Commissioners and ask for permission to do that. They won't meet after this bill becomes effective or is passed until April, that first Thursday in April. So that would kick off the process, and it's approximately 120 days of a process if everything goes right. You all know that nothing's really gone right in our office in the last couple of years, so it might be a little bit more lengthy than that. Meaning that we could have an impact on those leases where the process starts on September 1st. 4 months after that April date to September 1st, that's going to be maybe a tight time frame for us, which is why we were supportive of the July 1st, 2024. So we would ensure everything was in line and appropriate to move forward at that point.
Yes. Chairman Boner, go ahead.
And so it is my understanding that by adding section 109 and getting the rest of the leases put in the same time frame, was that what compelled you to want to, I mean, that's gotta be a lot more work, right? And so is that what compelled you to have the increased timeline than the later timeline? Or would you have the same position if we just didn't add that section 109 to the bill?
Yeah, Mr. Chairman, Mr. Co-Chair, that's a great question. It wouldn't matter. All of this requires a rule change on our end to make any difference. We have copied very closely, if not exactly, the existing statute into our rules. So any changes to these timelines also require a rule change as they're currently written. So regardless of which portion was passed, we would have the same issue. I think one important distinction, though, is that it's only effective to leases that, let me make sure I read this correctly, apply to all leases that are expire on or after July 2024. So everything happening in 2023 would not necessarily be impacted, and that relieves a little bit of administrative burden for us.
Okay. Other questions? Okay, so something you might explain or talk about a little bit is the rulemaking process. So when I was a fairly new legislator and I found out that we'd pass a law and suddenly the rules, which I think everybody needs to understand, these rules have the same, don't they have the same force as the statute? Once they're approved? Go ahead, Heather.
Mr. Chairman, the statutes are part of the rules, and then what the rules do is they fill in the details as far as I should have some in front of me to rather than just speaking, but they fill in the details for how to do what it says in the statute to do, and so they have the force of law because they've gone through and been promulgated and have had opportunity for comment and to go through the different levels of review. But their changing process is different than a legislative changing a statute. Changing a statute versus promulgating rules and amendments to those follows its own independent procedure.
Okay.
And Mr. Chairman, we believe that the rules have the force and effect of law as well. But to give you a little bit more granularity, we initially need board approval to move forward with regular rulemaking. It takes 10 days to get that permission, also from the governor, or he can give that permission within 10 days. We have a 45 to 50 day public comment period. We have a subsequent board meeting to ultimately approve changes to those rules based on all of that. Then we have to submit the rules to the governor's office again, to LSO and to the management council for their approval before they become effective. And all of that is expected to take about 120 days.
Okay. How might the legislators be involved in that rulemaking process? Is there a way for them to engage in it with the office?
Yeah, Mr. Chairman, absolutely, through the public comment period. And then I'm not sure, once it goes out of the final board review or board approval and it goes back to management council, I'm not sure if it comes back to the committee or not, but at that point, maybe.
All right, thank you.
Mr. Chairman,
Yes.
there's a specifically written into Title 28, the statute regarding the legislature, that an agency notifies the LSO if they intend to promulgate new rules. And at that time, the LSO sends a memo to whoever the prime sponsor of a bill that that prompted rules, whether that prime sponsor was a committee or an individual. And so LSO sends that memo to them to say, hey, they're in this process. And that way there is notice to them, whoever the prime sponsor was, to participate. It's not like they just have to somehow divine the fact that there's this comment period happening.
Go ahead.
And along those lines, for a committee bill, is that sent to the entire committee or is it just the chairman?
Mr. Chairman, I believe it's sent to the entire committee, but I will have a better answer for you in just a minute.
And so, Mr. Chairman, I think that's an important point to drive home when talking about rules that, I mean, there is an opportunity for the legislature to weigh in through management council. Now we could change that, potentially have to be the original sponsor needs to sign off on it. If that's a committee, that'd be the committee. The individual legislator, it's the individual legislator, instead of expecting management council to do it for us. But, you know, there is that follow-up from the legislative perspective to make sure that they are implementing the rules that in a manner which is consistent with our legislative intent. So I just want to highlight that. I think that got lost in some of the discussion here today, that does in fact exist, and you have to avail yourself of it. You have to actually do it. But that is part of the process for that reason, to make sure that the agencies are implementing our intent. So I'll be the first to admit I haven't been engaged in that process, because all the bills I passed have seemed to be implemented the way that I imagine them going, more or less. And so I just want to make sure that's abundantly clear.
Yeah, I've been involved in ones that allowed me to come and be a part of the rulemaking process, and I appreciated that. Nothing in the rules was inconsistent with the statute as I intended it, so didn't have any problems with it. Any other? Yep, Dan, Representative Larson, go ahead.
Mr. Chairman, thank you. Can we get the agency to maybe comment on the late fee of 10%, and if that's actually needed? Is it something we could figure out how to deal with that section on the amendment? It's in section 36.5109.
Mr. Chairman, Representative Larson, our intent to pull this portion into the bill was to try to marry up all of the deadlines to the same period of time. We think the bill as written or as amended describes a due date to be not less than 40 days prior to the expiration date of the lease, defines the due date as that, meaning that if you don't pay by then your 10% late fee kicks in at that point. We feel that it reads that way. Making sure that every time a lessee needs to make a payment to the office, the deadline is 40 days prior to the expiration date of the lease, marrying them all up. So from our perspective, I think it decreases confusion and increases clarity.
Okay, yeah, follow up.
Mr. Chairman, so how would we deal with a double up on a I guess if a leaser or the one leasing the ground has to pay in 1 year, this, double up, and then maybe have a penalty.
But Mr. Chairman, our leases and the rules and the statutes do expect a level of performance from the lessees. They have to pay. They have to do it by a set time frame. So if they don't pay, there should be a penalty to that. Paying more than once in a year, I think that this alleviates that. That was our intent. Obviously, this is a not later than 40 days prior to the expiration date, so they can pay anytime up to that, but they can also pay their renewal anytime up to that as well. So we feel like the timeframes are really married together. And if somebody pays twice in 1 year, it's because they made their payment at a different time each year.
Good, Representative, good. Okay, yeah. Chairman Boner, go ahead.
And so along the potential addition of section 109 to the bill, if we did change it, like the stalkers, I believe, testified to make it so the rent has to be paid by the anniversary instead of that 40-day period, would that be a huge disaster from your perspective?
Mr. Chairman, Mr. Co-Chair, not a huge disaster. What we're trying to do is increase clarity. And then that introduces another deadline into the 10-year cycle, and that's it.
Okay. Go, yes, go ahead.
Okay,
Senator
I'll
Boner.
go ahead and just make a motion, see how it goes to amend the bill. And so based off of the suggested proposed amendment by the Office of State Lands, make that amendment with the following adjustments. On page 2, line 17, instead of just inserting or another appropriate form of communication, have it read as follows. So it'll be in an appropriate form of communication as determined by and documented by the director. If no response is heard from the lessee, written notice shall be given, with some leeway to also make it sound nice. But you get the idea. So that's the first change to the amendment that I'm proposing. The second one.
Should we
Okay.
go ahead and deal with one at a time?
Sure, okay, so. Okay, and then the other change to the amendments would be on section 109. Make sure you still include on the anniversary and strike the due date. So that would be the amendment. And we would leave out the change in effective date for now. That could be a separate consideration. So hopefully that's as clear as mud, committee.
Second.
Heather,
Mr. Chairman, I just
Go
was
ahead.
wanting to confirm that so it'll become due and payable, but then if it's not received by the due date, then that's when they initiate their notice and stuff. Is that correct? In the 109? So the entire sentence. Okay, well, the portion of the sentence that's applicable would say that shall become due and payable at the office of the director not less than 40 days before the anniversary date of the lease. If the rent is not paid on the anniversary date, the director shall again notify of late fee.
That's correct.
Okay.
so we go back to that first language, and cross out the red letter by the due date. Good with that? Committee understand it? I think we're ready to vote. All those in favor of that amendment, say aye.
Aye.
Opposed? Okay. All right, any further changes or discussion? Okay.
I'm so sorry, Mr. Chairman, was that the entire amendment with the title changes and the cross references between B and A with those changes to it?
That's correct.
No.
And excluding the changes. in
And
the effective
excluding
date.
the back. Okay, thank you.
Okay, I see what we did. That would be, yep, that would be. Question on the bill? All right, we're all clear on the amendments. Okay, those, we're gonna have a roll call on this bill. Go ahead, Clarissa.
Mr. Chairman, this is a roll call vote for 23 LSO 201, State Land Lease Deficiencies Cure Process as amended. Senator French. Senator Cole.
Aye.
Senator Cost. Senator Wasserberger. Representative Blackburn. Representative Clausen.
Aye.
Representative Fortner. Representative Heiner. Representative Larson. Representative Western. Representative Worf. Representative Winter. Co-Chairman Boner.
Aye.
Chairman Eklund.
Aye.
Mr. Chairman, we have 12 ayes, 2 noes.
Thank you. Thank you, committee, and for everybody on the help with this. We'll have other time to refine it a bit, and I think we're probably hungry. So let's take off an hour for lunch. And when we get back, yes, sir. Are you buying, Dan?
No.
No. Okay. Okay, go, I'm sorry, go ahead.
Mr. Chairman, I'd like to make a motion to table the proposed draft for 103.
Sure. That sounds like
Or 134. Whoa.
the,
103 and 134.
okay, oh, yeah, complete this. Thank you. Representative, any discussion on that? This would be the other resubmittal bill that we looked at. That just needs a roll call. No, I mean, a voice vote, correct? Do I need just a voice or do we want to roll?
134.
All right,
134. Yeah.
just table it. All those in favor say aye. Okay. All those opposed, I'm sorry. Anyone opposed? All right. Blackburn's the only one opposed to it. He's, all right. We're going to take off an hour for lunch. So we'll see you. That'll be enough time.